ವೈಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಇವಾಗ ಮೇಡಮ್ ವೈಟ್ ತೊಗೊಂಡು ವೈಟ್ ಅದು ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಅಂತ
ಆವಾಗ ಕೊಟ್ರಲ್ಲೇ ಹೌದು. ಹಾ, ಬೇಗ ಬೇಗ ಬಹುಮಾನ.
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್
17. ಈಗ ಅವ್ರು ಬರ್ಕೊಂಡ್ಬಿಟ್ರು.
ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಸರ್ ಸುಮ್ಮನೆ ವೇಟ್ ಮಾಡ್ಕೊಡ್ತಾರೆ.
ಲಿಬರ್ಟಿ ಕೇಳ್ತೀರಾ?
ಲಿಬರ್ಟಿನೂ ಕೇಳ್ತಿದ್ದೀನಿ ಸರ್.
ಹೇಳಿದ್ರಲ್ವಾ? ಲಿಬರ್ಟಿ ಅಪೀಲ್, ಅಪೀಲ್ದಲ್ಲಿ ನೀವು ಇದನ್ನು ಗ್ರೌಂಡ್ ಮಾಡು. ಸರ್ಟಿಫಿಕೇಟ್ ಆಗತ್ತೆ. ಫೈಲ್ ಕಳೆದೋಗಿದೆ. Partition, reconstruction. Partition. For dispensation of institution. Particular. For bad luck, connected appeal is the partnership copy, certified copy. ನನಗೆ ಏನೋ ಜಿಮೇಲ್ ಬಂದಿತ್ತು, ಏನೋ ಜಿಮೇಲ್ ಬಂದಾಗ ಅದರ ಸೈಟ್ನವ್ರದ್ದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ನಾವು ಏನಾದ್ರು ಮಿಸ್ಟೇಕ್ ಆದರೆ ಇದ್ರಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಅದು ಆಶ್ಚರ್ಯ ಏನು 41 capital A is sent to the party not represented and sufficient. ಮಾಡಲ್ಲ ಅವರೇ ಬರ್ತಿದ್ರು ಆದರೆ ಸೆಲೆಕ್ಟ್ ಮಾಡೋದಿಲ್ಲ ಟೆಕ್ನಾಲಜಿ ಇರ್ತಿತ್ತು. ಅವಾಗ ಏನಾಯ್ತು ಎದರ್ತು ನಾಟ್ ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಬೇರೆ ಇದಕ್ಕೆ ಬಹಳ ಜಡ್ಜಿಗಳು ಏನಿರ್ತದೆ ಬ್ಯಾಡ್ರಿ ನಾಟ್ ಡೋಂಟ್ ಎಕ್ನಾಲಜಿ ದೆನ್ ಓನ್ಲಿ ವಿ ವಿಲ್ ಅಕ್ಸೆಪ್ಟ್. ಕೇಳಿದ್ರು ಫಾಲೋವಿಂಗ್ ನಾವು ಪ್ರೊಸೀಜರ್ ಬಂದಾಗ ಅದನ್ನು ಸರಿ ಕೊಡ್ತೇವೆ. ಯಾವ್ದಾದ್ರು ಕೇಸ್ ಮೈಂಡ್ ಅಪ್ ಮಾಡಿದ್ರೆ ಅದ್ರದ್ದು ಮತ್ತೊಂದು ಕೇಸಲ್ಲಿ ಅವರು he served and represented by a lawyer. No, not be a problem because he is already defending where the lawyer is. It is and sufficient ಅಂತ ಮಾಡಿದ್ರೆ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ. ಎರಡು ವರ್ಷ ಆರ್ಡರ್ ಆದ್ರೂ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತ ಸೈಡ್ ತಗೊಂಡು ಮಾಡ್ತಾರೆ.
ಈಗ ನೀವು ಪೇಡಿನೇಷನ್ ಹಾಕೊಂಡ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಯ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ ಬೇಗ ಬರ್ಬೇಕು. ಅವಾಗ ನೀವು ಎಂಡಿಂಗ್ ಅವರ್ಸ್ ಬಂದ್ರೆ ನಾನು ಐ ಫೌಂಡ್ ಇದ್ರೊಳಗಡೆ ಡಿ ಫೈಲ್ ಕೆಬ್ಬಿಲ್ಲೂ ಆಗಿಲ್ವಾ? ಆ ಕಾಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿತ್ತು 6267. ಇವರು ಬೋರ್ಡ್ ಅವ್ರನ್ನ ಕರಿ
Construction.
ಬಿಂದು ಯಾವ್ದೋ ಡಿ ಫೈಲ್ ಕೆಬ್ಬಿಲ್ಲ ಅಂತಲ್ಲಿ ಯಾವ ಡಿ ಫೈಲ್ ಇಲ್ಲ
Society cases, government cases, company cases.
ಸೆವೆನ್ ಹೇಳ್ಕೊಳಲ್ಲ ನಾವು ಎಷ್ಟೇ ಮಾಡಿದ್ರು ಸಿಕ್ಸ್ ಟು 27 ಏನ್ ಮಾಡಿದಾಳೆ ಗೊತ್ತಾ ಇವಳು ಅದು ಇದು ಲೋಕ್ ಅದಾಲತ್ ಮುಂದೆ ಡಿ ಆಗಿದೆ ಮೋಸ್ಟ್ಲಿ ಅದು ನಾವು ಸೆಪರೇಟ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟವಳೆ ಹೌದಾ ಯಾರು ಬಂದಿಲ್ವೇನೋ ಒಂದು ಡಿ ಫೈಲ್ ಕೆಬ್ಬಿಲ್ಲ ಅಂತ ಇವಳು ಮಾಡವಳೆ ಅದೆಲ್ಲಿ ಹೇಳವ್ರು ಅವ್ರೇನು ಹೇಳೇ ಇಲ್ಲ ಕರ್ಸಿ ಅವಳನ್ನ ಅಲ್ಲ ಲಾಸ್ಟ್ ಬಂದಿರೋದಲ್ಲ ನಮ್ಗೆ ಅದು ರಾಂಗ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ತದೆ ನಮ್ಗೆ ಸುಮ್ನೆ ಪ್ರಾಬ್ಲಮ್ ಅದು ಅಲ್ವಾ ಎತ್ತುತ್ತಿಲ್ವಂತ ಹೋಗ್ಲಿ ಬಿಡಿ ಅದು ಅಲ್ಲಿ ಇಲ್ಲ ಅದು ಇದು ಯಾವ ಡಿ ಫೈಲ್ ರೌಂಡ್ ಆಫ್ ಮಾಡಷ್ಟೇ 7086 ಅಲ್ಲಿ ಡಿ ಫೈಲ್ ಕೆಬ್ಬಿಲ್ಲ ಅಂತಾಳೆ ನೀವು ಡಿಸ್ಮ್ಯಾಂಟ್ಲ್ ಮಾಡ್ಬಿಟ್ಲ ಆರ್ಡರ್ ಶೀಟ ಇಲ್ವಲ್ಲ ಅದ್ರಲ್ಲಿ
ಹೌದಾ ನಮ್ಮ ಹೆಸರು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಬಂದಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿ ಅದೇ ಇದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಈಗ ಇದು ನಾನು ಮೆಮೊ ಹಾಕೇ ಕೊಡ್ತಂದ್ರೆ ಇದು ಸಬ್ಮಿಟ್ ಅಲ್ಲ ಅದು ಸಬ್ಮಿಷನ್ ಬಂದಿದೆ ಎಲ್ಲಾದ್ರೂ ಮೆಮೊ endorsement 2020 August 25 case number 4933 of 2020
economic ಕೂಡ ಅವ್ರದ್ದು 150
ಕೊಡಿ ಸರ್ ಏನ್ ಸಬ್ಮಿಷನ್ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡೋದಾದ್ರೆ ಮಾಡಿ, ನಂದೇನ್ ಸರ್. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಸಬ್ಮಿಟ್ ಯು ಸಬ್ಮಿಟ್. ಮೇಡಮ್ ನೋ ಸಬ್ಮಿಷನ್ಸ್ ಅಂತಾರೆ. ನೀವು ಮಾಡ್ಬೇಕು, ನಿಮ್ಗೆ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಯು ಸಬ್ಮಿಟ್ ಅಂಡ್ ಗಿವ್. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಮೆಮೋಸ್ ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ ಅಸೈನ್ ಆಯ್ತಾ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಬೋರ್ಡ್ ಅಲ್ಲೇ ರೆಕಾರ್ಡ್ಸ್ ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ರೆಕಾರ್ಡ್ಸ್ ಡೇಟ್ ಗಿವನ್ ಇರೋದ್ರಿಂದ 40-50 ಡೇಟ್ ಗಿವನ್ ಮಾಡ್ತಿದೆ ಪ್ರತಿ. ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಯು ಸಬ್ಮಿಟ್ ಅಂಡ್ ಗಿವ್. ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಏನು ಅಂತ ಕೇಳ್ತಾರೆ, ಯು ಎಕ್ಸ್ಪ್ಲೈನ್ ಅಂಡ್ ಗಿವ್ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ನಾವು ನಿಮ್ಮನ್ನ ಅಬ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಕ್ಕೂ ಆಗೋದಿಲ್ಲ, ನೀವು ಅಷ್ಟೇ ಅಲ್ವಾ. ಯಾಕೆಂದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಅನ್ಸುತ್ತೆ, ನಾವೇನೋ ಎಂಟರ್ಟೈನ್ ಮಾಡಲ್ಲ ಆತರ ಎಲ್ಲ ಇರ್ತದ, ಹಂಗಲ್ಲ ಅದು. ಕೊಡಿ ಈಗ ನೋಡೋಣ, ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಇದೇನು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಫ್ರೆಶ್? ಏನು FR ಅಲ್ಲಿ ಇದೆಯಾ? ಅದ ಸ್ಕೂಟ್ನಿ ಎಲ್ಲ ಮಾಡಿದ್ದೀರಾ ಸರ್? ಒಂದ್ಸರಿನೂ ಪೋಸ್ಟ್ ಆಗಿಲ್ವಾ? ಕೋರ್ಟ್ ಮುಂದೆ ಒಂದ್ಸರಿನೂ ಪೋಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ವಾ? ಪೋಸ್ಟ್ ಆಗಿ ಅವಾಗ ಆರ್ಡರ್ ಆಗಿದೆನಾ? ಅಲ್ಲ ಸರ್, ಇವಾಗ ಇದ್ರಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ವಾ? ಯು ಆರ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
Respondent of petitioner connected matter both arrears of maintenance ಕೊಡ್ಬೇಕು ಮತ್ತೆ ಮಂತ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಆಗ್ತದೆ.
ಮೇಡಮ್ GM CPC 22 ಎಲ್ಲಿ ಬರುತ್ತೆ ಮೇಡಮ್? ಇಲ್ಲೇ ಬರುತ್ತೆ.
22 ಇಲ್ಲ.
ಇದೊಂದು
It is as sir, whenever the provision court, whatever the provision court made the order, you go and follow it. You consult your advocate. The branch people will not entertain the clients when your advocate is on the. So move memo, ask your advocate to move. ನಾವು ಹೇಳಕ್ಕಾಗೋದಿಲ್ಲ ಯಾವಾಗ ಹಾಕ್ತೀವಿ ಅಂತ. ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಬೇಡ. ನೀವು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಮಿಸ್ ಆಗಿತ್ತೆ ಹೇಳ್ಬೇಕು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ. ಹಂಗಾರೆ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ, ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ. ಸುಮ್ಮನೆ ಇಲ್ಲ ಅಂದ್ರೆ ಯಾಕೆ ವೇಟ್ ಮಾಡ್ಬೇಕು?
ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್
ಸರ್ ಇದೇನ್ ಮ್ಯಾಟ್ರು? FR ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲಾನು ಟೇಬಲ್ ಹೋಗುತ್ತೆ ಸರ್. ಓನ್ಲಿ FR ಮ್ಯಾಟರ್ಸ್ ಅದು ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಇದ್ರೆ ಮಾತ್ರ ನಾವು ಹೇಳ್ತೇವೆ. ಅದರ್ವೈಸ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಚೇಂಬರ್ ಹೋಗುತ್ತೆ.
ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಲ್ ಹಾಕಿದೀನಿ ಕೌಂಟರ್ ಅಲ್ಲಿ.
ಇಲ್ಲ
ಸೊ ಇವಾಗ ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಆಗ್ತದೆ. ಪೆಟಿಷನ್ ರಿಪೆಟಿಷನ್ ಬರ್ದಿದ್ದೀರ? ನಾಳೆಗೆ ಇವತ್ತು 2:15 ಇವತ್ತು ಸರಿ, ನಾಳೆಗೆ
ಕೇಳ್ಬಿಡಿ.
It will send to chambers. ಇದೊಂದು ವಿಡ್ರಾಯಲ್ ಅಂತ ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ವಿಡ್ರಾಯಲ್ ಹಾಕಿದ್ದೀರಾ?
ಡೌನ್ಲೋಡ್ ಮಾಡಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 17. No, you submit. In the morning 10:30 only you submit. ಯಾವ್ಯಾವ ವಿಡ್ರಾಯಲ್ ಇದೆ ಹೇಳ್ಬಿಡಿ ಸರ್ ಬೆಳಗ್ಗೆ.
ನೋಡಿ
ವಿಡ್ರಾಯಲ್ ಮ್ಯಾಮ್ 17 ಅದು. ಹೌದು. ಅದೆಲ್ಲ ಕಾಲ್ ಔಟ್ ಆಗಲ್ಲ. 39 ಸರ್. ಅದೇ ಮೆಮೊ ಇದೆಯಲ್ಲ,
ಈಗ ಆಗೋಗುತ್ತಾ?
Bingo. ಬ್ಯಾಂಕ್ನವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ ನೀವು ಇದೆ ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಇರೋದ್ನೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಡಿ, ಯಾವ್ದು ಹೋಲ್ಡ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು ಅವ್ರಿಗೆ. ಹೇಳಿ ಅದು MI ಅರುಣ್ ಸಾಹೇಬ್ ಪ್ರಾವಿಷನ್ ಮಾಡ್ಸೋಣ ಕಳ್ಸಕ್ ಹೇಳಿ ಬೋರ್ಡ್ಗೆ, ಅಲ್ಲೋ ಕೇಸ್ ವರ್ಕರ್ಗೆ ಹೇಳಿ ನಾನು ಹೇಳಿದ್ದೀನಿ ನಾನು ಯಾಕಂದ್ರೆ ಅವರು ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಅಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ. ಅವೆನ್ ಅದರ್ ಕೋರ್ಟ್ ನಾಟ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್ ಅಂದ್ರೆ ವಿ ಕಾಂಟ್ ಅಸೈನ್ ಅನ್ಲೆಸ್ ದ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಡ್. ಅದಕ್ಕೋಸ್ಕರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆಗಿದೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇರೋದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಗೆ ಅಕಾಮಿಡೇಟ್ ಮಾಡಿ ಅಂತ ನಾವು ಅವತ್ತೇ ಹೇಳಿದ್ದೀನಿ ನಾನು. ವೈ ದ ಕೇಸ್ ವರ್ಕರ್ಸ್ ಆರ್ ಹೋಲ್ಡಿಂಗ್ ಐ ಡೋಂಟ್ ನೋ, ಅವರು ಹಾಕಲ್ಲ ಅಂದ್ರೆ ನನಗೆ ಫೋನ್ ಮಾಡಿಸಿ.
ಆವಾಗ ಇಬ್ರು ಪಾರ್ಟಿ ಪಾರ್ಟಿ ತಗೊಂಡ್ಬಿಡು ನಮ್ಮ ಒಂದು 15 ಲಕ್ಷ ಸಾಹೇಬ್ರುಗಳಿದ್ದಾರೆ ಅನ್ಕೊಳ್ಳಿ ಹೇಳಿದ್ರು. I was shocked. ಅದರ ಮಾತ್ರ ಒಂದೇ
ಪ್ರಾವಿಷನ್ ಆಗಿದ್ದು ನಾನೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆಗಿದೆ, ಕಳಿಸ್ಬಿಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
Little round. Same day. ಊರಲ್ಲಿ ಅವರು ಅಂತ ಹೇಳಿದ್ರು. ಸಂಜೆನೆ ಟೆಲಿಗ್ರಾಮ್ ಇದ್ದೀನಿ ನನ್ನ RFI ಕರೆಕ್ಟ್ RFI ಎಲ್ಲ ಇದೆ. ಅಂದ್ರೆ RFI ಅಂದ್ರೆ ಈಗ 15 ಹೊರಗಿಂದೆಲ್ಲ ಹೋಗ್ತಾರೆ. ಡೌಟ್ ಇರುತ್ತೆ. Litigation ಆಗ್ಬಾರ್ದು.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಹೋಗಿರ್ಬೇಕು ನೋಡಿ. ಮೆಮೋ ಕೊಡಪ್ಪ ಇವ್ರಿಗೆ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಅಂತ ನೋಡಿ. ಇಲ್ಲೇ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ? 24 ಅಲ್ಲಪ್ಪ, ಇದು ಆಲ್ರೆಡಿ ಪೋಸ್ಟ್ ಆಗಿತ್ತ. ಕೂಪ್ಲಿನಲ್ಲಿ ಇದೆಯಾ? ಅಲ್ಲೋ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೋಬೇಕು. ನಾಳೆಗಿದೆ ಅಂತ ನೀವು ಕುತ್ಕೊಂಡ ಪೋಸ್ಟ್ ಆಗಲ್ಲ. ಅದು ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ರೆ ಎಲ್ಲ ಮಾಡ್ಬಿಡಿ. ಬರ್ದು ಕೊಟ್ಟೆ, ಕಳ್ಸಿದ್ಕೆ ಇಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತಾಯ್ತು. ಸರ್ ಹೇಳಿ ಸರ್. ಇದು ಇದ್ದಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ.
Madam?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿದ್ರೆ ನೀವು ಅಲ್ಲಿ ಬರಿಬೇಕು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂತ. ಒಂದ್ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಕೋರ್ಟ್ ಆಗ್ದಲ್ಲ ಇದ್ರೆ ಮಾತ್ರ ಕೋರ್ಟ್ ಮುಂದೆ ಆರ್ಡರ್ ಆಗಿರೋದು ನಾವು ಮಾಡಿದ್ವಿ. ಮಾಡಿರ್ತೀವಿ. ಇವಿ ಬಂತು
Madam?
ಇರಿ ಸರ್, ಇರಿ ಅದು ಅದು ಒಂದು ಅದೇ ಅದು ಅದೇ ಅವೆಲ್ಲ ಅವೇ ಈ ಸ್ಟಾರ್ ಮಾರ್ಕ್ ಇರೋ
ಪಾಸ್ವರ್ಡ್
ಯಾರನ್ನಾದ್ರು ಹೇಳ್ಬಿಟ್ಟು
ರೀಚ್ ಆಗುತ್ತೆ ನೋಡೋಣ.
ಕೇಳ್ತೀನಿ.
ಅಲ್ಲಿ ರೀಚ್ ಆಗ್ತಾ ಇದೆ ಎಲ್ಲ ಕಡೆ. ಇವರು ಸೋಮಶೇಖರು
Meeting later, madam.
ಸರ್ ಬರ್ತಾರೆ.
ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಈ ನಮ್ದೆಲ್ಲ ಆಗುತ್ತೆ.
ಇಪ್ಪತ್ತಾರು ನಂಬರ್ ಪ್ರೋಸೆಸ್ ಬಗ್ಗೆ ಇಲ್ಲ.
36ನೇದ ಅದೇ ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಕಾಲ್ಡ್ ಅಂತ 36ನೇದ
ಇದೆ, ಯಾಕಂದ್ರೆ ನಮಗೆ ಏನು, ಹಾ. ಇವತ್ತೈತೆ.
ಏನಾದ್ರು
ಎಂಟ್ರಿ ಮಾಡಿ
ಅದೇ ಮತ್ತೆ ಪ್ರಾಸೆಸ್ ಬೇರೆ
ಪ್ರೋಸೆಸ್ ಕೊಡ್ತೀನಿ ನಮಗೆ ಗೊತ್ತಾ.
ಇವಾಗ ಕೊಡ್ತೀರಾ
ಇಲ್ಲ.
ಹೇಳಿ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಐ ವಿಲ್ ಕಂಪ್ಲೈ. ನಿಮ್ಗೆ ವೇಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಯು ಸಬ್ಮಿಟ್. ಏನ್ ಮಾಡಿಲ್ಲ ಫೈಲಲ್ಲಿ ಯಾವ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ಅಂದ್ರೆ ಆ 6227 ಇರ್ತಲ್ಲ ಫೈಲು ಡಿ ಫೈಲ್ ಕಟ್ಟಿಲ್ಲ ಅದನ್ನ ಈ ಬಂದ್ಲಿಂದ ಡಿಸ್ಮ್ಯಾಂಟಲ್ ಮಾಡ್ತಾರೆ. ಅದೇ ಇವಾಗ ಆ ಫೈಲು ಲೋಕದಲ್ಲಿ ಡಿ ಆಗಿದೆ, ಫೈಲು ವಾಪಸ್ ಕಳಿಸ್ಬಿಟ್ಟವ್ರಲ್ಲಿ. ಆಕ್ಚುಲಿ ಈ 7086 ಅಲ್ಲಿ ಕಟ್ಟಿಲ್ಲ ಫೈಲ್ ಅದು. ಅವ್ರಿಗೂ ಅಲ್ಲೆಲ್ಲ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ
ನಮ್ಮ ತಲೆಯಲ್ಲಿ ನಾವು 15 ರೂಪಾಯಿ
ಅಲ್ಲ ನಾನು 6227 ನನಗೆ ಚೆನ್ನಾಗಿ ನಾಲ್ಕು ಅವನೇ ಹೇಳ್ದೆ ಅಲ್ಲ ಫಸ್ಟ್ ತೆಗೆದುಕೊಂಡು ಹೋಗು ಅವರೇ ತಾನೇ ತರ್ಸ್ಕೊಂಡಿರೋದು ಅವ್ರ ಪಕ್ಕಲ್ಲೇ ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಅವರು ಮೇಡಮ್ mediation we didn't know. Like we can't instruct any case of this. ಅದು ಯಾವ್ದೋ ಅಪ್ಲೋಡ್ ಅಂತ ನೋಡಿ ಅವ್ರು ಮೇಡಮ್ ಕೇಳ್ತಾರೆ.
They will not apply to contempt of case.
Any permission?
Lordship kindly, a matter for vacating the interim order, my lord. For tomorrow, my lord. There is an urgency, my lord.
Which year is the writ petition?
2020, my lord. What has happened is that the summons is served on me now. They have filed the suit. The injunction, temporary injunction was not granted ex parte. My lord, they filed a writ petition here and obtained an order. Neither it is moving there nor it is moving here, my lord. File an application for vacating the
Give it to the court.
tomorrow.
We'll see.
One matter, my lord, expedition was declared as abated, my lord, file application for bringing a large. Lord, the matter is suit is posted for arguments on 5th, my lord.
When is it dismissed as abated?
That is, my lord, on 2/2. I filed application, my lord, on 1/3, my lord, 1/3.
1/3?
1/3, my lord, of 24.
Hmm.
My lord, 2/2, it was dismissed as abated, my lord. In fact, it was not, it had not abated.
When was it dismissed?
It was dismissed on 2/2, my lord, 2/2/24. But matter
Give
is
the slip, give the slip. Yes,
tomorrow or day after.
Application.
we'll see.
Lordship, kind permission. Serial number 36 of district 1.
This for payment of a process fee. I will pay the process fee today itself, my lord.
30?
36.
36.
Yes, 36.
One more
1 week.
one more process fee, I will pay today itself R1 bay. And I will also take out notice to the advocate on the trial court also. And interim order may kindly be extended, my lord.
Petition is permitted to take good notice on the council appearing before the court below and file a memo to that effect. Post this matter on on 19th of July. By the time, by 16th of July, the memo shall be filed, or else the petition will be dismissed on that ground. Interim order earlier granted is extended till then.
Number 39.
Yes.
For the petitioner, memo for withdrawal is already been filed. With the petitioner.
39.
39.
What has happened?
Memo is
No,
filed.
that is there. Why you are withdrawing? Did you say anything?
Trial court, not the suit itself.
Suit itself is, the a memo is filed stating that the main suit itself is disposed of. Hence, the petition is dismissed as withdrawn. The memo is taken on record. Yes. Serial number? FC of 2018-19 will not be adjourned unless and until the court sees the file, not in the time of mentioning. Yes. Serial number? 17. Huh. Yes, a memo is filed.
My lords, serial number 51, my lords.
Petition has, with the other petitions, a memo is taken on file and the petition is dismissed as withdrawn. Which item?
My lord, serial number 51, my lords. I'm for the petitioners, my lords.
Serial number?
Matter is listed today for in-chamber matter, my lords. There's small inconvenience for the petitioner to attend. My lord, me please to fix up a date, my lords. And the next date she'll be present.
Lordship, I object to this. 2 times in chamber with the child here.
Let's see, we'll look at that file. Let her take out the file. Is it sent to the chamber? Get that file. No, we will see what's happening.
One submission.
We'll take up this matter at, call that at 1 o'clock. We'll take up at 1 o'clock and appropriate orders would be passed. 17. Now, how can a liberty be granted without even looking at the file? What is that you are asking? No, that liberty, if you want liberty, please wait till the matter reaches. 17, don't record that order. Yes, next.
Being spoken to, serial number 1.
Do that. Yes, Mr. Patil.
Yes, I appear for appellant.
Yes.
Lords, serial number 51, my lords.
Serial number 51 will be called at 1 o'clock.
1 o'clock.
And you have to, we'll hear the matter on merits. Please argue. Yes.
Please, once.
For being spoken to.
Still pending.
Appeals are pending. One appeal is by insurance company. Another appeal is filed by me. So, order sheet, your lordship may reconstruct. Because in the other case, already they are served and represented.
Reconstruct because in this.
Order sheet, it appears it is misplaced.
It has come before
It
this.
has to be.
Where is that for being spoken?
Being spoken to, they have given the note.
Where?
From the chamber.
No, I didn't. I'm not able to understand that. What is that rebuilding? Hmm. Hmm. How can they give a note without even my knowledge? No. I should know what is happening.
I will say, my lord.
No, that's what is a surprise to me. How come it has come? We'll see. I'll find out what it is.
Appears after the dictation of an order was made, most probably it was typed and it was placed in some other file. That order is typed. So possibility of placing it is very remote.
Hmm.
It is
No,
very-
we'll find out what it is.
Reconstruction to be made, it is
That's
nothing.
what, no, for just like that, we can't ask for a reconstruction. What has went wrong, the court has to know.
Claimant's appeal for enhancement.
We will see, we'll see. We'll
Has to
see what
be-
it is. 1:30, Anita, in the chamber, let it be appraised. Yes.
Orders matter, scale number 2, K. Ravi Shankar.
When was the notice issued? Oh, this is this matter. Yes.
Let the application for amendment is to be rejected, that is
Mm.
called in question. The
Mm.
petition for divorce is filed by the husband on the ground of plurality
Yes.
under the Indian Divorce Act.
Yes.
But we filed a counter and initially we sought for dismissal of the claim in considering paragraph number 36 in page number.
No, first of all, husband has filed MC for divorce.
Right.
You
We
sought a
filed a
counterclaim?
No counter.
Uh,
Only counter seeking to dismiss the petition.
yes.
Thereafter, Milord, the parties have got the OS in between the parties. And in that regard, Milord, maintenance came to be granted, which was called in question before dishonorable court. Dishonorable court said go to the mediation, settle the matter. Milord, that was not possible, then ultimately it is returned back. Therefore, Milord, we said that he is making all sorts of allegations against the adultery and everything. Then we thought fit that the reconciliation may not be possible. Therefore, we wanted to amend our counter, stating that dissolve the marriage and permit us to give a permanent agreement. That is what is sought by an amendment. That came to be rejected because already evidence has been commenced. We cannot allow for
Evidence has already commenced.
commenced.
Let's see.
That is the reason.
Let's see the order passed for the court below.
Kindly turn to incident number 13. 1, Lordship's got it. Para 2, the learned counsel for the opponent petitioner has filed objection IA number so and so objection. It is contained that the present application dragged the case. The applicant is taking advantage of the leniency of the case. The respondent number 1 is tracking the case and the petitioner another. By filing the application in together. It is denied that in spite of the intervention, those of the dispute between the petitioner and the respondent number could not be sorted out. Because of this, it is not possible for the respondent number to continue the marital relationship with the petitioner. The trial has been commenced in this case and no amendment is permissible after trial. The case is now posted for further chief examination. The respondent number 1 is put up under. This is the reasons in page number 15, paragraph. In the present case, the petitioner has filed a maid petition seeking divorce of the main petition. The respondent number 1 and 2 appeared through their counsel and they have filed a counter and the objection. Thereafter, the petitioner himself examined PW and got marked so and so. On the other hand, the respondent herself examined as RW and got marked as so and so. Then the case is posted for further chief examination. RW1 has filed an IA number 6 amendment to delete.
When was notice ordered in this matter?
The notice is called to the 17/3/2023.
17?
3/2023.
What happened to that?
Thereafter, your lordships have once again permitted me to serve to the council. I have filed a memo yesterday. Look,
Yeah, that is served, but the council says the party is not in.
he is absconding. Now, before the trial court, by virtue of the FLW and everything has been issued, now he has come for the compromise and the compromise petition is also been filed. That is why yesterday I requested his lordship to defer by 2 weeks. If the settlement is down, report. Otherwise,
No, when he is not in contact with the
No,
advocate.
no. He's absconding because. of the
So like,
FLW.
even if you, if this matter is referred for mediation, he won't appear before the mediation center also.
Now, I have given an understanding that he has come for the settlement and the drafts have been given. It has to be not ratified, that's all.
No, when the client, when the advocate recently when he said about 3, 4 days back, when he gives an advancement on that, saying that from the last 1 year is not in touch.
Consider this. That's all, Millet, the paragraph 36, you will ask me kindly see the, what is the
Yes.
amendment.
Yes.
Link page number 39 of my count, Millet
Yes.
count.
Please come.
Yeah.
This petition is of the year 2017, 2023. And on the last occasion, this court has permitted the petitioner to take out notice on the counsel appearing before the court below. And the notice is served on the counsel. And a memo is filed to that effect. The petitioner before this court is the wife. Husband has filed MC seeking divorce. Initially, she filed a counter to dismiss the said petition. Thereafter, she filed the present IA, that is IA number 9 under Order 6 Rule 17 to amend the pleadings. It is by virtue of this amendment, the wife, and it is stated that in view of the false allegations made by the husband against her, she is not intending to continue the marital tie with the husband. Therefore, the marriage formalized between the between the parties requires to be dissolved by way of decree for dissolution of marriage, and the other relief sought by the petitioner in the petition deserve to be dismissed, and the petitioner should be directed to pay a sum of rupees 1 lakh. What is that? 1,50,000 towards the 50 lakhs, 1,50 lakhs towards permanent alimony. And further, he should be directed to hand over all the jewels and ornaments more fully stated in the counter C schedule property to the wife in the interest of justice. The said amendment came to be dismissed on the ground that the petitioner, the husband is examined himself as PW1, and the respondent has cross-examined PW1. And after closing the evidence, the respondent is examined as RW1, and the case is posted for further examination. At that time, this IA is filed, seeking amendment. As such, the same was dismissed by the court below. This court, having heard the learned counsel for the petitioner, submits that what the wife is seeking, the husband is seeking divorce, when the wife had also filed an amendment saying that she has no objection for that, and she wanted alimony. On the ground that the trial has commenced, the court below ought not to have dismissed the petition. As in the matrimonial proceedings, the court has to look at the substantial justice, and even by allowing this, no prejudice is caused to the husband. Next, having heard the counsel for the petitioner, peruse the entire material on record. Husband filed the MC seeking divorce. Now, by virtue of this, wife had also stated that she has no objection for granting divorce, but she wanted alimony of 1,50 lakhs. Even if on merits, if the court comes to the conclusion that it has to grant a decree of divorce, where the permanent alimony of the wife has to be considered by the court, just because she asked for 1,50 lakhs, or that is filed at the after the trial has commenced, cannot be the reasons to dismiss the petition. In view of the same, the order impugned is set aside, and consequently, I number 9 filed under order rules, Order 6 Rule 17 is allowed. Discuss.
Number 3, Ajay Prabhu M.
Time for the respondent.
Yes.
In terms of joint committee, but first of all, record to mediation. What matter, bylaw, right, municipal could have not reached the mediation center. They have come back. Mediation has not,
Was,
mediation has not taken place before the Mangalore Mediation Center. Madam.
on 27/3/2024, this court has referred the matter to the Mangalore Mediation Center and directed the parties to appear on 15/4/2024. It is submitted that as the file was not placed before the mediation center, the same could not be heard. The parties shall appear before the mediation center at Mangalore on 16th, on 16th of 16th of July at 3 o'clock. The Registrar Judicial is directed to communicate the same. Yes,
Interim order.
interim order earlier granted is extended till the next stage of hearing.
Till number 4,
I appear for the petitioner's minutes.
This matter, my lord, there is nothing to.
Notice to the other side served.
They are refusing to receive the notice. I'm filing an affidavit to that effect. My lords had directed me to serve it on the advocate appearing on behalf of the respondent.
No, if they refuse, then we have to see the other mode of it. That's not the ground to allow the petition.
The only question before this court is, my lord, whether video conferencing can be a mode for adducing evidence.
Yes,
That is the only question. I am supported by, my lord, the honorable.
correct. On the last occasion when you argued, that's what the court has said. Now it's a case where it has to be allowed.
Please.
Now, the court can't allow it without a notice to the respondent.
Notice is ordered, but it is not served upon them yet, specifically for the reason that they are refusing to receive it. In the interim, my lord, I must bring to this court's knowledge. When this court ordered notice on the 10th of June, which was almost a month ago. 12th, they move another revision petition before the coordinate bench of this honorable court and obtain an order in our absence, wherein maintenance is ordered to them. The very advocate who refused to receive notice from us on the ground that he has given NOC on the same subject, my lord, he has appeared in the matter, my lord, and-
Whose MC is this?
my lord, I have preferred, this is the husband's MC on the ground. of
The-
other-
Now this, if the MC proceedings are stayed,
No, I do not.
that's the only, then that's the only interim order. What else you expect from the court?
Well, only to the effect that, my lord, the CFSL director who has ordered the report confirming that the father is not the father of the child, his evidence must be recorded. He writes a letter to the.
No, that's on the
honorable-
merits of the matter. Now either it has to be an interim order. Interim order can only be stay of all further proceedings. That is your MC. So that's not to your benefit.
Become.
So
the product.
we'll take out notice by RPAD to the party, to the advocate. The petition is permitted to take out notice by RPAD to the advocate as well as the party. Advocate appearing before the court below and also to the respondent and file a proof of service. 2 weeks?
11th or 12th, my lord.
No, it's court has no problem, provided you can serve post on 11. Yes,
till number 5, human hearing. Satish PJ.
Now, challenging the order, page number 53 at Annex G. The interim maintenance ordered by the letter trial judge to what to the wife, to 10,000 to the interim maintenance. Addition to that,
yesterday this came.
get the
Now you said 20,000, 10,000.
the respondent is continued the premises.
So now you need to pay 10,000.
Yes.
So how much you will pay now?
5,000.
How many months?
But from 4/7/2023, date of the order.
4/7?
4/7/2023 till disposal of the case. As order passed by the learned trial judge, in page number 6.
So 5 months here and now we are in seventh month. So 12 months.
Please.
Oh. Please come. The husband is before this court, agreed with the order passed with the trial court, whereby the court had granted an amount of rupees 20,000 maintenance to the wife, and if 20,000 maintenance to the wife, if she is staying in the rental accommodation and in which the petitioner is paying the rent, and if she is not, no, the court had granted 10,000 maintenance to the wife. If she is using the, residing in the accommodation which is provided by the petitioner, it is 10,000, otherwise 20,000, otherwise it is 10,000. And counsel for the petitioner submits that the court below had failed to consider the income of the husband and all the relevant aspects for consideration. When the matter came up yesterday, this matter is adjourned to today to get specific instructions whether she is continuing in the accommodation provided by the husband. On instructions, he submits that she is continuing with the very same, in the accommodation which is provided by the husband. And as per the order of the court, in that event, she has to pay, the husband has to pay 10,000 maintenance. Considering the submission of the husband, there shall be stay of all further proceedings on the condition that he continue to pay 5,000 per month by 5th of every succeeding month, and at 5,000 for 12 months arrears comes to 60,000, which has to be deposited within 4 weeks from the date of receipt of the copy of the order. Either 5,000 or that is not complied, the order passed by this court stands vacated automatically without further reference to the court, and the petition shall take out notice on the counsel appearing before the court below and shall file a memo to that effect. Memo shall be filed by 26th of July. Pose this matter on 5th of August. Yes.
Seal number 6.
Connected appeal is filed, Madam. We have also filed for enhancement, WP 16,347. It may be posted
What
to
is the
the
number?
WP 16347 of 2024.
Just repeat it.
13347
16347
of
2024. WP.
We'll have it tomorrow along with it. Post along with the connected writ petition tomorrow. Yes.
Seal number 7. E group.
Pass over.
Seal number 8. Madhukar Deshpande.
Yes.
By filing of that, there was a mutual consent petition filed by them. It resulted in.
Anita, what's the back door this time?
Resulted
One
in
door.
mediation.
Oh.
And thereafter, mediation agreement was placed before the court, and matter was disposed as, divorce was granted and decree was drawn. Subsequently, my lord, there are certain circumstances that happened in the petition which shows that even after the divorce was granted, they were living together as husband and wife. That particular petition is filed, my lord, and the particular divorce was granted, there was no pre-consent. I have produced certain photographs as well as videos.
No, what is the order impugned before this court?
Please, my lord. I
Yes.
request my lords to kindly take annexure A, that is the impugned order, my lord.
Yes.
Thereafter, my lord, I have filed.
Page
a
number.
recall-
No, first let's see the impugned order, then we will,
So the impugned order is at page number 20.
yes.
When I filed a recall application before the.
Let us read it.
Case is taken on board as per the application filed by the petitioner number 2 with notice to other side. Petitioner number 2 present, petitioner number 2 has filed interlocutory application under section 151 of CH to recall the judgment and decree dated 4/1/2019 on the ground of fraud said to have been committed by the petitioner number 1. The order sheet reveals that petitioner number 1 and 2 had filed petition under section 13B of Hindu Marriage Act for dissolution of marriage by mutual consent. The said matter was referred for mediation. During the mediation, the parties had resolved their differences and settled all the issues, including alimony maintenance. Accordingly, memorandum of settlement came to be executed. Both the parties had signed the memorandum of settlement. The memorandum of settlement entered into between the parties was accepted and recorded by the court on 4/1/2019. In terms of the memorandum of settlement, the petition filed under section 15B of Hindu Marriage Act came to be allowed and marriage of the petitioners 1 and 2 has
So by filing an application under 151, the court can't go into all these issues and court has permitted you to initiate appropriate proceedings. And then what is wrong in it? When a judgment and decree is passed, what are you supposed to do? You don't file a petition to set aside the judgment and decree by a petition under 151. You have to file a petition to set aside that under which provision? Or 23 rule 3, yes.
Under order 23, my lord, if there is a compromise between, then we go before that particular court.
No, it's a compromise one, basing on your settlement. It's a compromise decree drawn. Where is that order? You have gone before the same court.
Yes, my lord, I have filed before the family.
No, but not 151. Now, unnecessarily, from the year 2019, you file a writ petition and you're looking at it here. When the court has given you it has not dismissed your petition. It only said permitted you to initiate separate proceedings. You could have filed before the court.
My lord,
Why MFA? Why you should file MFA?
that I filed the NFA before this article. And that came to petition on maintainability. But
Yes, it is not maintainable.
However, I was given the liberty to file the petition before the article.
Court will not tell you what is your remedy. Unfortunately, this is not your remedy.
My lord,
There is nothing, now the fact remains is, whatever is the order of the court, absolutely, there is nothing now under 227. We have to look at what is the illegality with the order passed by the court. There is no illegality. Court was perfectly right. What did the other court say in MFA? Those are not the considerations for deciding this application. Unfortunately, this has to go. No. Why the matters be just like that pending on the file of this court without any basis? And why this litigation be always in the air? Get instructions, pass over, no adjournment.
my lord, kindly, my lord, this 2 days.
No. Post this matter tomorrow maximum, not more than that. Post this matter tomorrow on the top of the list. Yes, next.
For 9. Quorum is C for petitioner.
Give the docket. Right from 17/8/2023, on all the occasions, except on one occasion, on all the occasions, the writ petition is adjourned at the request of learned counsel for the petitioner. Today, there is no representation on behalf of the petitioner. Pose this matter for dismissal on 10th of July. Yes.
Cell number 10. Sundar Raman for petitioner.
Yes.
Petition has become infectious to the reason that the execution has been closed. The execution proceeding has been closed.
Completed.
Yes. The award has been set aside. The present petition arises out of an execution petition, which is in respect of an award.
Learned counsel for the petitioner submits that the execution proceedings are closed. And as this petition is filed, questioning the execution proceedings, as such, this has become infractious, dismissed as infractious.
17 March, this court had granted me an interim order against the order of attachment by the execution court, under which I was required to furnish a fixed deposit of 19 crores. My lord may pass a direction to the trial court to relieve me of that condition. 17th March 2020.
Then I need to know what is the order passed by the court below, how the execution proceedings are closed.
Please, the execution proceeding were closed because the award was set aside. I'll file the certified copy of the order.
What is the order passed by this court?
This court 2020. So in the execution proceeding, an order of attachment was passed, against which the present petition was preferred.
Stay of order, subject to the petitioner furnishing security of fixed deposit to an extent of award amount of rupees 19 crores to the satisfaction of the so-and-so. Automatically, once this order goes, that also goes. You don't require a specific order.
The trial court has not recorded to that effect. My lord, you should include that as well, that.
This court, in the end of the order, all miscellaneous applications, everything stands closed. So this also will go. This court by order dated 17/3/2020 has granted stay on the condition of subject to the petitioner furnishing the security of fixed deposit to an extent of extent of award amount of rupees 19 crores to satisfaction of first additional district judge, Dakshina Kannada, Mangalore. Land counsel submits that there may be a clarification to the court below in this regard. When the writ petition is dismissed and when all the interim applications are closed, no further direction required to be given to the court below. Yes.
Bill number 11.
Therefore, respond.
Yes.
Matter was heard by your lordship's lord last week.
Yes.
Lordship's directed to furnish the typed copy of the order sheet in OS 18.
Huh? It is there. Give him also. Let's see what is the order.
Annexure G is the impugned, my lord. order.
Annexure D.
G, my lords. Page 50.
Huh.
Lord, this is appellate court's order setting aside the order dated 15/4/2019.
What is the
Order dated,
application?
my lords,
What is the application before the trial court?
yes, my lord. In the first instance, my lord, written statement was not filed by the defendant. This is by the defendant, my lord.
Huh.
And then an application was made seeking to recall the order that closed the written statement, my lord, filing stage. And my lord, that application was rejected, and the presiding officer posted the matter for judgment. Then after the change of the presiding officer, one more application was filed under Order 47 Rule 1 CPC, seeking to recall the order, first order that was actually passed by the other officer. And that application was allowed by the successor officer on the ground that I was not there when the rejection order was passed. And the learned trial judge has allowed that application. Against that, my lord, we filed MA. In MA, my lord, the appellate court has set aside the order of the trial court, allowing IA for, my lord, seeking permission to file written statement, etc. And my lord, the reasons or grounds on which the application has been, my lord, the MA has been allowed is that the defendant did not file the application under Order 47 Rule 1 within time fixed under Article 124, that is 30 days time. The other ground was that, Lord, the application filed under Order 47 Rule 1 did not contain the grounds that are specifically provided in Order 47 Rule 1. Nextly, the court said that if the matter is posted for judgment there remains nothing more to be done, relying on the division bench judgment of the court, my lord, our high court. The court said that once the matter is posted for judgment, nothing more is to be done, and there is no question of giving permission to file written statement at that stage is the order. And my lord, relying on the Supreme Court, the court has held that if a right has accrued to a party on account of an order passed by the court, that order cannot be nullified in the guise of reviewing it, and a review cannot be treated as an appeal, as has been done by the trial court, not in its order.
I think I remember like within a matter of 1 year, the case is posted for judgment.
Yes.
Now let's see the docket proceedings, how it went on.
And another thing is that the defendant had filed a suit, my lord, for declaration of his ownership and also injunction against us. That, my lord, suit was dismissed by the court. And initially, an order of injunction, temporary injunction had been granted. That was also, my lord, vacated after hearing us.
Yes.
And that has not attained finality. The order of the court in OS number 307 has, my lord, attained finality, and this suit had to be filed by the, my lord, present respondents, because after vacation of the interim order in OS number 307, he started, my lord, attacking us aggressively. And I also brought to your lordship's notice that most of the land we had purchased from the father and grandfather of the present petitioner, we had sold it. What is remaining with us is only about 10 acres, and Lord, that we are in enjoyment. He does not actually go against the persons who have purchased the property from us. Lord, he keeps on, Lord, attacking us is one thing. Second thing is that he has created about 10 agreements in favor of different persons. I have filed, my lord, the paper publication issued recently by him, wherein he has cancelled all of them.
Now let's just see the docket proceedings.
Lordship may kindly take the first order is at annexure E.
No, no, docket, this
Yes, order sheet.
order
order sheet.
proceed,
Yes,
the order sheet.
please.
I think it's a typed copy you have filed.
Type it.
Where
Page
it
number
starts-
26, your lordship.
Page number 21, 29, it will start.
It starts at 29.
26, from
Yeah.
page number 26.
Let's see. When is the notice served to the defendant?
No notice has been served to us. We have, no.
Yes.
There is a
25, Lord,
Where
25,
is that, which page?
25/8/2018, your lordship may.
25,
8, 2018.
One
Page
minute.
number 28, your lordships may kindly come.
D1 to 13 PPF through RPA, reissue, served, acknowledgement put up.
Yes.
So notice is served on 25/8/2018.
Then, my lord, time was given till,
Then in respect of D9 and D12, door locked, no such person.
yes.
Is D1,
Defendant number 4, my lord.
defendant number 4 is the petitioner now.
Yes.
D458. File forward to defendant number 679 and
They have not, in fact, typed this order, my lord, of the court. Dated 25.
So on 7/11/18 itself, the defendant's side not filed, written statement is taken as nil.
Yes.
That was passed on 7/11/2018.
Yes. Thereafter, my lord, on 9/1/2019, court allowed IA1 filed under order 39 rule 1 by plaintiffs and posted
But
the case for
plaintiff filed on IA number 1.
evidence by 16/2/2019.
7/1. When was the application filed?
Application was filed, my lord, on, no.
To recall that one,
First application was filed on 29/3/2019,
29,
3/2019 or 30/3/2019, 30th March 2000.
30th March 2019.
Mm.
Uh, That came to be dismissed on
15/4/2019, my lord.
15,
4/2019.
then they will not question it.
No, they have not questioned it. That has attained finality.
Then when will they file another petition?
My lord, they filed another application on 27/6/2019.
Is this a separate application
Yes,
or a review on that IA?
this is styled as review application. It is styled as IA under order 47 rule, my lord,
Uh.
1.
Review of the order stated 15/4/2019.
Yes,
This is called IA number,
IA number is not given.
so for review.
Hmm.
Filed on 27/6,
2019, my lord.
which came to be allowed on
My lord, it was allowed on 31/10/2000, my lord, 19. Annexure F,
31/10/2000.
19, my lord. Against this, we filed MA number 15093 of 2009.
That was allowed
On 6/2/2020,
6/2.
2020, my lord.
So another 4 years here.
Not 4 years, 1 year, roughly 1 year.
So you said
Oh.
6/2/2020.
Hmm.
Now we are in 24, another 4 years in High
Yes,
Court.
yes, yes.
Now, when your written statement was treated as nil, on which date?
My lord, it
On
was-
7/11/2018.
Yes.
On 7/11/2018, what were you doing till 33/2019?
Because of the health issue, he did not come.
Huh?
Because of health issue, he was having some problem with his stomach. So he was.
Where did you say so? Let us see your applications, IA. And that is one aspect. Then thereafter, your application was dismissed on 15/4/2019. You should have assigned the same by filing a writ petition, which you kept quiet. Till the next presiding officer comes, then he reopens the case. Then because now it is reopened, now let me file this application. What is the justification on the part of the defendant in doing all this?
Because of health issue only. That's
Hmm?
the only reason.
Let us see. That's why let's see the IA, what is happening.
They have not produced, I have produced along with my objection statement as annexure R4.
Page number?
My lords, 49. With my objection statement,
40?
49, my lords. At page 51, please look at it. Kindly come to page number 51, my lords. This is the application. Application under order 47, rule 1 of CPC for review of the order passed in IA number 3 dated 15/4/2019. That the petitioner defendant number 4 has not filed any appeal before the appellate court or any other court against the order passed by this honorable court on IA number 3 dated 15/4/2019 seeking permission to file the written statement. Therefore, the defendant number 4 is entitled to file this review petition.
So where is that reason for not coming to the court at an earliest point of time, right from 7/11/18? Nothing. You don't say anything in the affidavit. Either,
We have said in the affidavit, ma'am.
Huh?
Affidavit we have said. Affidavit, in affidavit of.
I am looking at the affidavit only. Affidavit dated 27/6/2019.
Not this one, the previous affidavit we have, previous, the 151.
Huh?
What we have filed previously,
Hmm.
that we have mentioned in that affidavit.
Then in that you have mentioned, then what is that you are doing once your petition is dismissed? What are you doing till the next presiding officer comes and he reopens it? You didn't say anything. This is what they have filed at page 51.
My lord, as petitioner was not feeling well, he could not approach the office, hence we could not file the petition in time, my lord.
Nobody,
it's my
nobody
humble-
can stop, no, if he, that all, everything by, can't be supplemented by
yes,
way of argument.
Yes.
In a civil proceedings, you need to specify that there should be an averment, nothing.
Yes, yes.
At least not one occasion. Lapses on the part of the petitioner on 3 occasions. Once, initial stage at when it's taken as null, nil, as you said that he is not well.
And para number 5, you can see, we have mentioned regarding his health, para number
Yes.
5.
Yes,
It is further submitted that another ground on which the IN number 3 was rejected in the, is the defendant number 4 was present in the court on that day and he had not filed any written statement and also not opted for cross of PW1. It is true that on that day, that is 2/3/19, the defendant number 4 was.
this is the reason given by you
Yes,
when
ma'am.
your evidence was treated.
Further I have said, ma'am, further.
Yes, I read the whole para.
Yes. So the defendant was not well. With the assistance of his son, he was present in the court to request for time, but however, the court has not granted time. And proceeded further. Mere the presence in the court that itself is not sufficient ground to deny the natural justice. Therefore, looking in the circumstances of the case and worth of the property being more than ₹400 crores involved in the case, an opportunity of filing the written should be given, cannot be denied, and core principles of law of natural justice be provided to the defendant number 4. This is our request.
That is all with regard to the first. As on the day when your written statement was treated as nil. Then what about the next? So court has to presume that there is absolutely, you're not interested to pursue the litigation. Now, whenever you feel like you'll come up with applications and courts have to allow it. Please come.
Opportunity given for the defendant.
Huh?
One opportunity given. File the written statement.
ಇದು ಹೇಳಿ ಸರ್ವಿಸ್ ಆಗಬೇಕು ನಾವು ವಾಲಂಟಿಯರ್ ಮಕ್ಕಳ ತಾಕಿ ಬಂದಿತ್ತು ಅಂತ ಹಿಂಗಾಗಿತ್ತು ಅಂತ ಹೇಳಿ.
Agreed with the orders passed in MA number 15039 of 2019 dated 6th February 2020, whereby the appellate court has set aside the order passed by the trial court. The defendant is before this court. The respondent plaintiff had filed a suit for
Permanent injection.
permanent injunction.
Yes, no. Permanent.
Had filed a suit for permanent injunction. In that, notice to the defendant was served on 25/8/2018.
One small correction, Your Honor. It was stated below, RPAD unserved to defend number 1, 2, 3, 4, 6, 7, 9 and 12. And voluntarily we have appeared before the court.
You are
Yes,
appear,
yes,
you are
yes,
there on
yes,
25/8.
Yes, it was admitted.
He is defendant number 4. He is
Huh.
not concerned with not other.
You notice the defendant appeared before the court, defendant number 4 appeared before the court on 25/8/2018. Thereafter, as a written statement was not filed by the defendant, on 7/11/2018, the written statement was treated as nil and the court had proceeded with the trial. Then an application is filed on 30/3/2019 to recall the said order that came to be dismissed on 15/4/2019, stating that already the case is posted for judgment and at this point of time, allowing any of the applications would not arise. Then the application is filed on 27/6/2019. To review the order dated 15/4/2019 on the ground that the earlier application was dismissed as the matter is posted for judgment. As now, as a new presiding officer has come and the matter is reopened, as such, the order may be recalled. Then the court, by order dated 31/10/2019, has recalled the said order and permitted the petitioner to file the written statement. Aggrieved thereby, the plaintiff has carried this matter in MA number 15093 of 2019 to the on the file of the fifth additional district and session judge, Bangalore Rural at Devanahalli. By way of the order impugned, the court had set aside the said order passed by the trial court, wherein the appellate court has observed that
Number 10, page number 59.
yes. The court had considered the scope of Order 47, Rule 1, and the ground on which the order of the learned judge dated 15/4/2019 was reviewed by this order is not within the scope of Order 47, Rule 1. The court observed that the trial judge has not considered the point of limitation while entertaining the review petition. The judge has failed to address the issue of limitation under Article 124 of the Limitation Act. And accordingly allowed the application, allowed the MA. Agreed by said order, the plaintiff is before this court. Learned counsel appearing for the petitioner, plaintiff submits that, defendant submits that, agreed thereby the defendant is before this court. Learned counsel appearing for the fourth defendant, whenever it is stated defendant, fourth defendant. Learned counsel appearing for the fourth defendant submits that they could not file the return statement within the period of 30 days as the advocate, the defendant was not feeling well. And as on the day when the order was passed on 15/4/2019, in fact, they have come to the court. They sought for adjournment as counsel is out of town. The court, without considering any of this, has dismissed the petition. It is submitted that for giving a fair opportunity to the defendant, the court ought to have allowed ought not to have dismissed the same. And that too on the ground that the matter is posted for judgment. He submits that when a review petition is filed, seeking to review the earlier order, when the trial court had rightly passed an order, the appellate court, without any basis, has interfered with the same and dismissed the RA, allowed the RA without more on technicalities. MA, more on technicalities. Next part. Then a senior counsel appearing for the respondent plaintiff submits that the defendant number 4 earlier with respect to the you said something like with respect to the very same scheduled property.
Lord, OS number 307 of 2016.
For which we have filed a miscellaneous.
2000.
That
That is also dismissed.
No, we'll record his submissions.
Yes.
307 of.
In respect to the very same property, the plaintiff in the suit has earlier filed OS number
307 of 2017.
17 seeking declaration and injunction.
Declaration and injunction.
Injunction.
Not the plaintiff, it is the GP holder of the plaintiff has filed it without the knowledge of the plaintiff. Knowledge of the petition he has filed.
That's what, the declaration and injunction, which came to be decreed, by judgment and decree dated,
Dismissed, my lord.
yours,
Dismiss the non-prosecution.
This OS 307 filed by him was dismissed, my lord.
that is filed by him for declaration
Yes,
injunction.
yes.
OS number so and so is filed by the plaintiff, by the defendant number 4, who is the petitioner herein, seeking declaration and for permanent injunction, which came to be dismissed
Non-prosecution.
16/9/2019.
16/9/2019. Against that, they have filed,
MA against that order, that was also dismissed.
against that,
That is
MA.
during the pendency of the suit. This suit is dismissed for non-prosecution.
Against certain MA is filed, that is pending,
That's also dismissed.
that is dismissed. Against that, now,
Miscellaneous 29/8 of 2003.
23.
20 is pending.
Miss petition 28 of 2023.
Miss petition
28 of 2023.
28 of 2020 is pending here.
Not here,
23.
before the Same court. Seen as limited.
23 is pending before the court below. It is submitted, it is stated that
It is his statement, my lord. We are not aware of miscellaneous
No,
petition.
already they have filed it. They have
Your
filed the
lordships
appellate
are referring to my submissions, my lord. So miscellaneous petition is not within our knowledge.
So what is, what should be recorded there?
Then, my lord, the next year R2 is,
That RA is filed,
No, no.
MA was filed.
MA was filed,
It has been dismissed on 13th December 2017.
MA was filed and it is dismissed on 13th,
December 2017.
17th.
Conviction matter.
In response to that, then counsel appearing for the defendant submits that they have filed a miscellaneous petition and the same is pending consideration before the court below. It is submitted that the defendant conveniently had kept quiet when the court had treated his application dated 7/11/2018 as nil and come up with an application after 4 months. And when it is dismissed on 15/4/2019, again without pursuing the same, he kept quiet. And now he comes up and then after a new presiding officer has taken charge, then he will file an application for review. Then a senior counsel submits that as that is beyond the scope of a review, the court below had rightly dismissed the petition. And the appellate court had rightly allowed the MA filed by the, Huh?
Referring some judgments.
not required for.
Please.
For the changing circumstances, we
As
have filed
rightly
it. For the changing circumstances, we have filed that IG.
filed MA number as rightly allowed the MA as the trial judge has gone beyond the scope of the review. It is submitted that a party cannot be permitted to applications which are made by a party who is not diligent in pursuing the matters cannot be entertained. And the petition is liable to be dismissed. Next paragraph. Having heard the learned counsels on either side, peruse the material on record. When the matter came up on the last occasion, when the arguments were advanced, looking at the fact that the suit is of the year 2018, and the application was dismissed on 13/3/2019. As there was no much delay, this court initially wanted to allow this writ petition and asked the learned counsel appearing for the petitioner defendant to file the docket proceedings, the order sheet of the court below before this court. In the proceedings of the court below or placed before this court has thoroughly gone through the said proceedings, wherein it discloses that the notice is served on 25, the defendant number 4 had appeared on 25/8/2018, and an order treating the evidence as nil was passed on 7/11/2018. This court observed that for filing an application to recall that order, the defendant had taken 4 months' time. Thereafter, the same was dismissed on 15/4/2019. Then, when an order is passed by the court, he has not chosen to file any appeal against the, he has not chosen to avail the appropriate remedy against that order. He waited till the next officer comes on 31, and he files the application on 31/10 to the, on 27/6/2019. And that came to be allowed on 31/10/2019. That application is filed as a review. Looking at all the docket, the court proceedings, it appears that there are no bona fides on the part of the defendant in pursuing the matter and filing these kind of applications. When the court had dismissed his application on 15/4/2019 and posted for judgment, then everything is, everything is closed for the petitioner. The only remedy is to come before an appellate court and question the said order. When he kept quiet, and if the other presiding officer, if the same presiding officer continues, then it has to be assumed that in that event, he had no grievance against that order. And the appellate court had rightly held that the scope of the trial judge had gone beyond the scope of review and allowed the application on 31/10/2019. The considered opinion of this court, looking at the conduct and the manner in which the matter is pursued, the petitioner, that this court cannot give an opportunity to the defendant, and the order passed in MA number is a well-considered order which do not require interference of this court. Yes, accordingly dismissed.
But well, Sumantra.
Also appear for the respondent in this
Petition
matter.
filed by the wife.
Which item?
Question number 12, Halesha Arji.
Yes.
Petition. I am appearing to petition.
Yes.
The trial court, before the trial court.
My lords, may make the submission, my lords. My lords, in WP number 15468 of 2021, in which I am the respondent, not received the copy, my lords.
When you have filed your wakalat? It's coming up in B group.
Please, my lords.
No, when was your wakalat filed? Wakalat filed on?
My lords, subsequently in petition number 25926 of 2022, I am the petitioner.
I'm
my lords.
looking at this. I'm looking at 15468. When did you file your wakalat in this? And now in 2024, you tell the court that you don't have the papers. What is to be done?
My lords, one humble submission, my lords.
Huh?
Matter may be listed on next week, my lords. We'll argue both the matters, my lords. Please, my lords.
Now, you are also questioning the same order. You know what is the order of the court.
Please, my lords.
So why papers are required for you in this? What he would give?
Please, my lords.
That's an excuse, isn't it?
It's an excuse, my lords.
Please prepare yourself and come. No adjournment. Give him papers. We'll have it day after tomorrow.
No, my lords. Senior is out of station, my lords.
Then that was, you said some other reason now. That papers are not served.
Not yet departed any amount granted by either by trial court and.
Is there a stay in 12.1?
Well, 10,000, subject to the payment of 10,000 per month, stay has been granted.
Then we will do one thing.
Please, my lords.
We'll vacate the order in 12.1 and that your senior at his convenience come and argue. In 12.1, we will vacate the interim order. Let them proceed with the execution. At the convenience of your senior, you can come and argue.
My lords, or else let it be maybe listed tomorrow, my lords.
Tomorrow. And by that time, if no amount is deposited, we'll vacate the stay in 12.1. 13.
Case number 13. Mr. Narayan Sharma.
Partition law.
Yes.
Duly paid to the suit, the time of delay, the paid participation.
In a suit for partition, you are the plaintiff. Who, you filed an application? On the ground? When was the sale? When was the suit? No, a property which was sold in the year 2003, a suit that is filed in 2013, you file in 2019 to implead them. What is the relief you are seeking? What you have not equity. Now the issue is, you have to seek for the cancellation of the sale deed, you have to seek for the cancellation of the sale deed. Well, something is, there is a registered document in his favor, which is of the year 2003. Yes. If it is not binding, what it should be done? It should be declared as not binding on you. Now, when is your knowledge about that? Till 2019, you didn't know that the property is sold. Please come to the order. Page number.
Relevant portion is 39, madam.
Now, initially, these two properties were not the suit schedule properties. Initially, no, it says, subsequently, the plaintiff amended the plaint by including other two properties.
What they are claiming, madam, all.
1 minute. Please read from para 10. Yes, what do you say?
My lord, kindly for a moment, come to the plaintiff, my lord. What they are mentioning in the schedule, my lord, they are seeking only for the 39 gundas, my lord. Total extent of the survey number 35 1 6 acre, my lord, 6 acre 30 gundas, my lord. They are not claiming all the social property as a partition, my lord. Only 39 gundas as claiming, my lord. I purchased the 1 acre 20 gundas of the social property, my lord. More, my lord, I purchased in the property in the year 2003, my lord. They know the, my lord, kindly, for a moment, kindly come to me. Para 3, my lord. Para 4 of the plaint, page number 12, my lord. They aware the sale deed made against me, my lord. It is submitted by the plaintiff that the depend number 1 to.
Minute, 1 minute.
Please,
Page number 12.
please, ma'am. Para number 4, madam, 11.
Yes.
It is submitted by the plaintiff that the dependent number 1 and 4 have sold the first item of the suit share property in the name and favor of the sixth dependent without the knowledge and consent of the plaintiff and other daughters. The said alleged sale deed executed by the dependent number 1 and 4 London void. But they are not stated, my lord, anything of the total extent. And for a moment, my lord. Item number.
This is with regard to your property.
Please, my lord. Totally extent of 39, survey number 35, but
That you are aware of it only in 2019.
already sold it executed. Is purchased.
Yes. Heard, resort. Yes, next. Next.
Still number 14.
Please, my lord, appear for the petitioner in this matter. Have a submission. The advocate
Yes.
record is no more. His name may be deleted and my name may be shown, my lord. Please, my lord.
Who is no more?
But Sri D.S. Hosmat, my lord. Advocate for petitioner.
What is your name?
Vinay D. Hosmat.
Delete the name of Mr. T.S. Hosmat and instead put in the name of Vinay D. Hosmat. Yes.
Please. And one more submission. Matter may be taken up next week. I'll come physically and argue the matter. Because he passed away recently and due to certain rituals, I'm unable to attend the court today physically.
Next week. Pose this matter on 16th.
Please, my lord. Much obliged.
Still number 15. Petitioner.
For the respondent.
Right.
That is the reason why I moved the matter. Before the RA court, they say that writ petition is pending.
Oh,
And
you
before
moved
this
the-
court, a judgment has been passed in the year 2003. Judgment is passed in the year 2003. We have filed an
What is
execution.
it here?
Let's, taking a delivery of possession. Delivery of possession has already been taken. This petition becomes infructuous.
Let's see what is it.
Let's, page number 117. 117 is the
Huh?
typed copy is at 117, my lords.
You said
117.
1?
117, 117. Order dated 1/2/2022. Let's, a suit for specific performance was filed, came to be decreed. Let's, suit was decreed in the year 2003. 13, my lords, I'm sorry. 19th October 2013.
Suit is of which year?
2013,
Suit is of 2013.
30,
Decreed on
19th October 2013.
ex parte decree.
Plus, they represented the matter, but they filed wakalat, but they did not,
1 minute, I'll hear you.
they filed wakalat, did not contest the matter,
So 19th October 2013, suit is decreed.
decreed.
Ah,
Plus, we filed an execution in 2014.
2000?
Sale deed was executed in our favor.
When?
Let's, on 3/12/2021.
Now, against this ex parte judgment and decree, they have not preferred
They
any
have
appeal.
now filed, they have already filed miscellaneous 8 of 2021 before the same court. And they have already also filed RA 82 of 2022 before the district court, which are pending considerations.
He filed the same application
Plus,
for the court.
they have filed it, my lords.
And again, another appeal, regular appeal before the other court.
They have already filed regular.
When did you file the RA?
2022.
Now, when the decree is executed and, sale deed is executed on 3/12/20.
21 months.
So till such time you are waiting. Why to fix? How does it matter? Whatever happens. No, you know that, you know about the institution of suit. You know that the suit is instituted. Then whatever it is, no, from 2013 till 2022, you didn't even bother to know what has happened to the suit. Or does the court permit you for this kind of latches? Correct. Within 5 months, suit is decreed for 11 years, 12 years, you didn't realize that. When is the MFA coming, RA coming before the court below? No, why this will come in the way of RA?
No, this will not come in the way, but that is a submission being made since there's a stay granted by the Honorable High Court.
For the petitioner seeks time, then counsel for the respondent submits that. As this writ petition is pending before the court on that ground, the appellate court is not going ahead with the
RA proceedings.
RA proceedings. It is so unfortunate that pendency of it is so unfortunate that because a writ petition is pending, if the court is not, when there are no orders, orders by this court, staying any of the proceeding before the RA.
Execution proceedings are stayed before this honorable court.
Because
Execution,
RA is a different.
RA is
When there is no order by this court, staying proceeding before the appellate court, the court ought to, the court has to proceed with the same. This has made it clear that any order passed in this writ petition would not come in the way of the appellate court in proceeding with the matter. That's what I clarified. Then come on 16th, no further adjournments.
Much.
Post on 16th, no further adjournments will be granted. Yes, next.
Number 16.
To appear for the respondent number 2 in this matter. Lord, may I make a humble submission? My Lord, the impugned order is in Kannada, my Lord. Yeah. That is at Annexure A, my Lord. It may require a translation because there is a detailed order on a compromise, my Lord. Let them file a translation.
The counsel, the petitioner. Is there any stay from this court?
No, my Lord. Because everything is over, my Lord. There is no stay action.
Then we'll unnecessarily why to trouble him for a translation. Pose this matter on 29th.
Please, my Lord, it may be required. That is the reason, but I have no.
No, not that. I'm saying, so by the time he
Yes,
does
yes.
the translation, some other judge who knows Kannada might be.
Please, my Lord. Please, my
So
Lord.
for that, we'll have it on 29th.
My Lord, may I see, trial court records may be called for, my Lord. There are some documents which are referred in the order.
Call for the trial court records. 30th. Yes.
Much obliged.
Then number 17.
No.
Santosh S. Nilkudri.
You want to withdraw with the liberty. What is the order impugned now? Huh? Dismissed as withdrawn. Memo is filed seeking to withdraw the petition. Same is taken on record and dismissed as withdrawn.
But in the memo, liberty is sought, my Lord.
But the court is not given.
It's all.
Till number 18. Ramesh H.E. for petitioner. Rahul.
It's on the mics. Yes.
Amount was paid on 1,80,000.
Who is the petitioner?
I'm for the petition in this case. No,
Petition is a plaintiff or the defendant?
no, he's the executive, he's a DHR.
DHR.
No, he's the DHR, my Lord. I'm the
You're the judgment debtor. What is the suit for?
Suit for recovery of money, my Lord.
When was it decreed?
It is in the year 2016. 16, my Lord.
What is the order impugned in the execution?
Impugned order, my Lord, there is a decree of the amount which was paid. The defendant is hereby directed to quit and vacate the delivery vacant position.
My Lord, if I
suit
may, my Lord,
property.
it was a suit for eviction.
Not recovery of money?
No. On that, there were arrears.
Yes.
In 2016, it was decreed. And there was a condition that he has to vacate the property by 3 months by paying all the arrears. Then I file an execution in number 2506 of 2017 in the same year. In that, we enter into a joint memo and we file a joint memo before the local Lok Adalat of senior citizens. And we mutually agree for a lesser amount, that is 3,25,000 rupees.
3,25,000. Original, what is the amount?
I may. It was 375.
3,70,000.
For 3,25,000.
Yes.
Then
after that, he refuses to comply with that compromise petition.
that is recorded.
That is recorded. It is there in page number 39, my Lord.
Dated?
That compromise is dated 15/5/2019. Well, sorry. That is, within that time, he shall pay that amount.
Then you filed EP.
Then I file EP.
Uh,
That EP, he compromise was not done. So I file one more EP, execution. I file one more execution. That so and so was the compromise by joint memo. He has not complied with that for that. And there was an attachment warrant issued so that I could go and execute the matter. Meanwhile, this writ petition he has preferred, and this writ
And
petition is
attachment order is dated,
attachment order dated
order impugned.
Yes. 14/9/2022, 20 months.
21
Page number,
in order sheet.
The order sheet 43 starts from 43 million. In that
please come to page 39. This is
47,
dated 14/9/20.
47, on 4/6/2022, they issued.
39 is the order on that.
Hence AWS to JDR.
39 is the order.
39 is
Please.
the order.
Please read the order.
Orders on IA number 2, that the CPC holder, the decree holder has filed an application 150 praying that issue warrant against the judgment debtor. In the affidavit accompanying application, the decree holder submits that he had filed a suit in West Number also against the judgment debtor for the relief of eviction on suit scheduled property, and this court decreed the suit on 6/10/2018. He filed an execution petition on number 25006 of 2018. Same was amicably compromised between the parties before the before special Lok Adalat to the senior citizen held on CCH-23 in the terms of joint memo filed by the parties. The judgment debtor agreed to pay arrears of rent in installments. First installment of ₹75,000 shall be paid on or before 15/5/2019. Second installment in sum of ₹1,25,000 shall be paid on or before 15/6/2019. Third is final settlement on ₹1,25,000 shall be paid on 15/7/2019. The decree holder who submits that the judgment debtor has not complied with the order of the court clear and pay the aforesaid sum of ₹3,25,000 is agreed. The consequent upon the default on the part of the judgment debtor, this court issued an attachment warrant against the judgment. The decree holder along with the court bailiff visited the residence of the judgment debtor and could not able to find any valuable things to compensate the decree amount. Hence, they could not attach any movable properties belongs to the judgment debtor. If the application is not allowed, the great hardship prejudice.
So this court, this order is for arrest.
Yes, madam.
No, therefore the decree holder has to take steps for attachment of the mobiles.
Please.
You only said that
No,
please
but
attach
what
the
has happened,
properties,
my lord?
that mobiles.
No, what has happened, we have given an articles in the shop, but they did not agree for the articles. He is selling they did not agree for the articles. We have given a list of articles, my lord. In that value also given, but that they did not agree. We are
So what is that now they are going to attach?
no, apart from that, my lord, he doesn't have that.
If you don't have anything, leave it then.
No, already keys are already handed over, my lords. In the earlier, much earlier, keys handed over to him.
Please come to page 44.
Let's, at that point of time, my lords, he was not, immediately after that, he
What is the
vacated and
situation
given.
now?
My
Mr.
lord.
Counsel,
My lord,
what is the situation now?
situation now is, there's been, this,
My lord,
because of this writ
I'll
petition, we
take-
have not executed, my lord. They are
Remaining
pending
amount
of
is
3,75,000 rupees.
No.
It is not about remaining amount, the court is not concerned. What is the order here? The court has directed for attachment of articles.
Yes, my lord.
That has,
Which
my
you
lord,
come before this court and obtained an interim
yes, my
order.
lord. In that situation, my lord, we have paid 1,61,000.
That we are not
And-
going into, that is before the executing court, whatever is required to be done
No,
and whatever is the
No,
calculation. they will
interim
take
order
care
is
of it.
concerned, my lord, we have complied it, my lord. Interim order as the only thing is, my lord, we have given a cash of ₹24. That they did not accept it. They're saying that we are not receiving any cash. For before that, before the executing court, my lord, we have submit that we have paid the cash in at the time of executing the at the point of execution, my lord. We have given a cash. That is along with the memo I produced it, my lord.
Are they accepting that you have, they have
No, but
received
that
it?
24,000 they are not accepting, my lord. Thereafter, my lord, we have given an one more DD That is 24,000 we have deposited. Entire amount has been deposited for the this honorable court interim order.
Where is the order?
Yes. Order was.
Subject to payment of a
Please.
sum of rupees?
On
Respondent,
29th July 2022, my lord.
No, the entire amount is not paid.
No, I'm not saying that I didn't pay any entire amount, my lord. Only the part of amount has been paid.
1,85,000
Yes, my lord,
is
that has been paid. That has been paid, my lord. I have
Where is
produced,
the memo?
let's, in that memo,
Look at it.
it is there in the,
That was the condition for the stay.
yes,
So was it deposits? Was it paid
but
to you?
18/11/22 to
It's not been
2022,
received
my
by
lord.
us.
How did you pay?
Yes, my entire amount has been deposited. Not entire amount.
I'm asking you, how did you pay? What is
Plus,
mode
one
of
is amount,
payment?
one amount is 1,61,000 is the DD.
Ah,
On 23/8/2022. Remaining balance was collected by the respondent on 25/7/2022 at 3:35 PM by way of a cash in front of Nanjunda Swami HT, Court Amina.
Did you
Police.
pay any amount by way of cash?
No,
If you don't
that-
agree for that, if you say that he has not received, how do you prove it?
In front of the bailey, my lord, and one Mr. Constable, police constable, and his brother also was there.
Then now, why you now don't have any instructions? What is the payment? How much is,
Lord, 1,61,000 has been received.
and what about that money
No.
he is referring to?
No, my lord, it's not. been.
Another amount, my lord, 24,000
No,
also
if it
paid.
is- If
That is
if
the-
it if
it
at all
is,
it has been deposited there, my lord, the only question which has to be discussed now is to be his eviction, my lord.
That's 18/11/2022.
And there is a compromise wherein he agrees that within 3 months, he'll evict the premises.
That has been already done, my lord.
My lord,
Thing
it's
is,
a
the
settled
amount has
principle
been
of law.
Amount,
the compromise
amount
is
is
entered.
due, my lord, because he is unable to pay because of Corona.
But what to do? What the court can do for that? It can't,
no, let's-
forever stay will be granted to you.
Thing
No.
is, my lord, the concern, the only concern about 25,000, my lord, is a very poor, my lord, he is not doing any business. He's not doing, he's working
It's a
somewhere. else.
judgment and decree,
No, that is true. my
which is staring at you. Unless and until he
No.
compromises or he agrees for whatever it is, court cannot compel him to do.
lord. For that, my lord, yes,
Whatever has to follow, has to follow.
1,85,000 rupees has been complained, my lord.
No, 3,75,000.
That is,
He agreed for 3.25. No, 3.25, again you can't bargain.
No, for that, my lord, 50,000 has been, if he fails that, he has to pay extra 50,000.
No.
That is,
This
is-
court is not concerned with what is happening. No, this court is concerned only with the impugned order. There is nothing wrong with the impugned order. We'll dismiss the impugned order. Whatever has to follow, we'll record what is the order of the court and what is your contentions. And that he is not accepting that payment of so-and-so.
cash is concerned, my lord.
That
Only-
before the executing court, if you have
That
to
may be,
prove it.
because that liberty has to be reserved for me, because I'm unable to prove it apart.
Why
from
did
that.
you give like that?
No, at that point of time, my lord, because he is running a business at that point of time, my lord. If they close the shop, he cannot do the business. That is the reason he has paid 24,000 at the spot. He is received from his brother 11,000 and he has withdraw from the ATM. That also I produced along with, I kindly will.
It's always for you to prove it, that this court can't.
On
there is no
18/11,
question.
18/11/2022. The lordship
That
kindly-
your memo and the order both will record and let it is,
Please, please.
we'll set aside this order first. This interim order and we'll
Please,
dismiss your writ petition.
please.
Please come. Agreed by the orders passed in. Passed in I number 2 in EX number 25287 of 2019 dated 14/9/2020. The judgment debtor is before this court. The respondent herein, who is the decree holder, had filed OS number 25696 of 2017, and the court below, and the trial court has granted a decree, has allowed the same by way of a judgment and decree dated, what is the date of judgment and decree?
Judgment and
On
decree.
6/10/2018.
Please.
Then the judgment, then the plaintiff had filed then the judgment decree holder has filed execution petition in 25006 for 2019. The same was, and as per the same, the defendant had the judgment debtor had to pay an amount of rupees 3,75,000. As per the compromise entered between the parties before the special Lok Adalat for senior citizens, and in terms of the joint memo filed by the parties, the judgment debtor agreed to pay arrears of rent in 3 installments. That is, first installment, the sum of rupees 75,000. Second installment, the sum of rupees 1,25,000. No, first installment, the sum of 75,000 to be paid on 15/5. Second installment, the sum of 1,25,000 to be paid on 15/6. And the final installment, a sum of rupees 1,25,000 to be paid on 15/7/2019. As the judgment debtor failed to comply with the same, he had filed the present execution petition. It is stated that earlier, when the court has issued attachment warrant against the judgment debtor, the decree holder along with the court bailiff visited the residence of the judgment debtor and could not able to find any valuable things to compensate the decree amount. Hence, they could not attach any movable properties belonging to judgment debtor. As such, they filed the present application to issue arrest warrant against the judgment debtor. The judgment debtor has filed his cross objections, stating that he is tenant in possession and enjoyment of the suit scheduled property. It is stated that he is unable to pay as he has incurred losses in his business. He has filed a memo along with articles worth about more than 3,75,656, and the decree holder has refused to recover the articles from the judgment debtor. It is stated that the application filed for arrest is not maintainable, and accordingly sought for dismissal of the said petition. The court below, considering the submission on behalf of both the parties, and according the contention of the judgment debtor that now the articles that now also is ready to recover the articles of more than 3,75,655. The articles are already in the shop, which are branded articles. Therefore, the decree holder has, court has ordered that the decree holder has to take steps for attachment of mobiles and immobile properties standing in the name of the judgment debtor. Agreed thereby, the petition has come up before the petitioner decree, judgment debtor has come up before this court. When the matter came up before this court had granted stay on the condition subject to the payment of an amount of rupees 1,85,000 to the respondent within a period of 4 weeks from the date of order. And the said order is extended from time to time. In compliance with the orders passed by this court, a memo is filed by the petitioner stating that he has handed over DD of rupees 1,61,000 to the decree holder on 23/8/2022. Remaining balance was collected by the respondent on 25/7/2022 at about 3:35 PM by way of cash in front of Nanjuda Swami HT Court Amina Police Constable, his brother and brother-in-law. He has collected the money from his brother, an amount of rupees 11,000 withdrawn from the Indian ATM, and remaining rupees 44,500 from the shop and from his pocket. Is it not litigating further?
No, it's not that, my lord. To show that it's not a litigation. Only thing is that if they are accepted, my
Submitted that they've complied with the interim order. Now, when the matter came up for hearing, then counsel for the respondent submits that, except the DD, They have not received any cash. It is the contention of the learned counsel for the petitioner judgment debtor that he has paid the amount as per the order passed, remaining amount as per the order passed by this court by way of cash. Before going into the said aspect, now the order impugned before this court is the order for attachment of movables and immovables of the judgment debtor, except stating that his business is not good and he is not able to pay the money. Nothing else has been stated. In the earlier execution proceedings, a settlement was entered into between the parties whereby they were, they have arrived at an amount of rupees 3,25,000 from an amount of rupees 3,75,000. Now, in the execution, in the second execution proceedings that are instituted, it is stated by the judgment debtor that the articles can be recovered and an order is passed both for movable and immovable properties. When there is a judgment and decree which is staring at the petitioner, which has attained finality, the judgment debtor has no other option but to pay the amount, and the decree holder is always at liberty to realize the decretal amount by way of, by available means and with the judgment debtor. This court finds no infirmity with the order passed by the executing court, and accordingly, the writ petition is dismissed. However, it is made it clear that whatever is the disputed amount, the judgment debtor before the appropriate forum has to prove the same.
Yes, may I make one submission? On 5/11/2022, 24,000 by way of a DD, 5/11/2022, DD number 258897, that is the next one. That also paid, entire amount has been paid. That is
What entire amount?
interim order entered.
Ah,
That has to be.
DD, what is another DD?
Another DD, 24,000. The last one.
1,61,000 is one DD.
Please, madam.
Another DD is?
24,000.
Yes,
It is there.
Serial number
he submits that by way of another DD. Drawn on which bank?
It's drawn on Indian Bank, Commercial State,
He had paid another 25,000,
24 minutes.
24,000.
Please.
All these payments, taken by, huh?
I give.
Yes. That to stood off.
I'll deposit.
Yes, next.
serial number 90.
Permitted to withdraw.
Yes, absolutely.
Yes.
But the amount it can be permitted to withdraw, however, it's deposited.
Yes, deposited before the trial court. The amount that is deposited by the petitioner, judgment debtor, the respondent decree holder is at liberty to withdraw. Yes,
May I, my lord?
yes.
The judgment debtor,
Petitioner is the plaintiff or the defendant?
dependent,
Defendant.
yes.
What is the suit for?
The suit for possession,
Suit for?
suit for possession,
Possession. And what is IA?
application. This, one second. There are there are four applications. One IA number 21 for police help filed by the other side.
In execution, now this arises out of the execution
Yes,
proceeding.
in execution.
Please come to the impugned order.
Yeah, that is at page 59.
29.
29, sorry.
59.
59.
59.
Page 60, will kindly be seen.
59.
Yes. the JDR number 7.
Hmm.
Applicant has filed a application under section 151 to recall the order dated 1/10/2019 passed on IA number 21.
What is this order dated 1/2/2019?
1/2/2009 is the police help was ordered.
Page number?
My lord, that is not 1/2/2009, that order is not before the court. my lord.
No, I have produced it, my lord, at
Yes.
annexure R15 along with my statement of objection.
R
46.
46.
6.
Hmm. Suit is of which year?
Suit is
99,
of
my
the
lord.
year 1999.
99.
Suit.
Suit decree
When was it decreed?
decreed on 24th July 2007. 4th July
2007.
2007.
Execution petition was
No
filed.
appeal is preferred against
No
this.
appeal is.
There is
Execution is filed?
in the year 2008. The bailiff's report on the application is at page 28. That was on 9/8/2000.
This,
The entire
no, I am looking at this IA numbers 22 and 23.
22 and 23. Yes.
Which
May-
filed by him at
Yes.
page number 26.
Yes. May read, my lord.
To permit the bailiff to break open the locks of suit premises.
To break open the lock of suit premises and to direct KPTCL to disconnect the electricity supply to the structure.
What is the suit schedule property?
My lord, the exact detail of the suit schedule property is not forthcoming. That is why all this is happening. Suit schedule property is 30 cents of land. My lord, kindly see annexure A, decree, page 14. Schedule B may kindly be. Description of the schedule B may kindly be seen. This description of the property situated in Kottattaru village of Udupi Taluk, survey number 184/1, extent is 30 cents. And kindly see the next page description. The above property is part of 60 cents in occupation of the defendants, out of which 30 cents is land is granted by the land tribunal in so and so, and the above 30 cents is the other portion of 60 cents encroached upon by the defendants. My lord, this is the identity of the property is not yet approved. By this bailiff also gives a.
You're reading all this from where?
My lord,
I'm looking at 15. It says
kindly come
suit
to
for
page.
directing the defendants to vacate and surrender vacant portion of 30 cents of
Page
property.
17 and 18 is
Page
reading.
17, my lord.
17 and 18 is reading.
Description of the property.
Decree is clear.
Decree is clear, but B schedule. Now the whole question is, which is that B schedule? That has not been identified so far. B schedule. Because, my lord, the entire extent was 60 cents of land. In that, the petitioner before my lord and others had applied for grant of occupancy right. To an extent of 30 cents, it was granted. 30 cents was granted, there is no dispute about it. The remaining 30 cents, they say that the remaining 30 cents belong to them. There is a suit for possession and a description given at schedule B. And there is a decree. Our contention is what we are in possession, that is shown in schedule B. Identity of this 30 cents where we have a house, all of us, small houses, all 1 cents or 2 cents. And this identity of 30 cents is not true. Bailiff report also says that it cannot be identified. I'll take my lord through this. Now, this is the Schedule B. And I may have to refer to,
Oh,
yes.
a piece of land is 60 cents.
No,
30
no,
cents?
my lord. Piece of land is not 60 cents. Piece of land is more than 60 cents. In that, 60.
When the government has allotted a land to
Government
them,
has not allotted. Owner, he is the owner, owner's successor. We filed application under section 48 of the Land Reforms Act. Under the Land Reforms Act, there is a provision to grant of occupancy right to the persons who are tilling the land. And all of us, the defendants, were granted with 5 cents, 3 cents, or 8
there
cents.
will be a description to that.
A description is not forthcoming in the entire.
There is a description for their occupation, for the lands which are allotted to
Yes,
them.
because there is a sketch drawn by the surveyor attached to the land tribunal. That is what it is referred. In one of the orders, it says, as per the surveyor's report of the land tribunal, this should proceed. Therefore, I think reading page 31 sketch and the report would help us to come out to see what is the exact land which is.
So with this, right from 2008
Yes,
till now, execution is pending.
execution is pending. And the identity of the property of the land 30 cents could not be established. Without identifying that particular 30 cents.
Let's now go to that 42 page number order.
Please.
It is dated 7/2/2019.
Yes.
Yes. Please read that order.
Page 46.
Yes.
Annexure 50. The instant applications have been filed by the decree holder under Order 21 Rule 35(3), read with Section 151 of CPC, to permit the court bailiff to break open the locks of suit premises and to direct the KPTCL quota to disconnect the electricity supply to
No,
the.
I'm looking at page 43 of his papers. That order dated 7/2/2019.
Yes, madam. That is
what is
he refers
asked
to R15.
1-2-19 is at page 46, my lord, R15.
1-2-19, my lord, as where is the application, order on this?
No.
Yes, annexure.
No, the impugned order is which page?
Annexure J, page 59.
59.
Yes.
There, they seek for setting aside the order dated 1/2/2019.
Yes.
Where is that 1/2/2019
That is
order?
at page 46 or
46.
Yes.
Yes.
The instant applications have been filed by the decree holder under Order 21, Rule 35, section, read with Section 151 CPC, to permit the court bailiff to break open the locks of suit premises and to direct the KPTCL quota to disconnect the electricity supply to the structure existing in the suit premises and to issue delivery warrant accordingly. In the affidavit, the GPA holder of the decree holder has stated that when the court bailiff went to the suit property to carry out the order of this court to execute the delivery warrant, the judgment debtors purposely locked the illegal structures thereon in order to stall the delivery proceedings and to frustrate the decree. Accordingly, the bailiff was unable to execute the order of this court and reported the same. It is necessary to issue direction to the court bailiff and to the concerned KPTCL as paid for, hence the application. JDR number 7 filed objections to the present applications by stating that the same is not maintainable. It is stated that IA number 24 dated 31/10/2015 was rejected by holding that it is not prima facie maintainable. The sketch prepared by Mr. So-and-so surveyor is illegal. The GPA holder of the petitioner made an attempt to gulp the property by holding the petitioner. The entire property shown in green, blue, saffron, and pink color in the sketch are situated within a common enclosure and forms a single compact plot. My lord, that is placed at annexure E, my lord. That will make it clear. The persons in whose favor the said properties have been granted are close relatives. It is settled principle of law that no court can go behind its decree. The applications filed by the GPA holder of the petitioners are not maintainable. The prayer sought in IA number 23 is not sustainable under law. The GPA holder of the petitioner intends to mislead the court. Applications, so and so. Now,
So those applications are allowed.
those applications
Then
are
what is
allowed.
this application to recall that order?
Recall that order that IA number 28 annexure.
You have contested that case, in that IA. There is a question of the recall of that order on what ground?
Because, my lord, kindly come to annexure E, page 34, that makes it clear. The sketch.
Under which provision this is filed?
151.
Hmm.
151 provision, because the sketch is not properly, that is, kindly say that order also does not refer properly to the sketch. The sketch makes it evident at page 34.
No.
The total
No, no, no.
extent.
In the earlier order,
Yes.
you have raised all these contentions.
Yes.
With regard to the color, which is yours, which is not, all that contention. The court has given a finding that it is not, it will not go into all those aspects.
No, the court has not gone.
Please come again to the order dated 9/12.
Yes.
Please come to where your contentions are addressed with the court.
Yes, yes. Reasons.
Yes.
With reasons starts at paragraph 7.
Yes, please read.
Court may kindly go to,
Yes.
I shall read. In the instant applications, the GPA holder of the decree holders has clearly contended that as per bailiff report, the door was locked and the bailiff has also reported the court to pass necessary orders to hand over the vacant portion of the suit property to the decree holder. On perusal of the bailiff report dated 24/11/2016, it is clear that the said bailiff had visited the suit property to execute the delivery warrant as per the order dated 5/11/2016. This court has also provided necessary police assistance to the court bailiff along with the WPC to execute the delivery warrant. As per the report, the court bailiff has failed to execute the same. As door of the structure house situated in the suit property was locked. The bailiff report further discloses that as per the court order, 10% of the house of JD number 3, 50% of the house of JD number 1, and 90% of the house of JD number 5 have to be vacated, and there is every possibility that the remaining portion of the structure may get damaged. In view of the above report, the counsel for the decree holders came up with the present two applications. As the bailiff report clearly shows that the door was locked at the time of his visit to the suit property, there is a possibility that it was locked only to defeat the decree to delay the proceedings. GPA holder of the decree holder has rightly applied for an order to break open the locks of the buildings. One more application is filed by him seeking direction to KPTCL quota to disconnect the electricity supply to the structure situated in the suit schedule property. The bailiff has clearly reported that only the portion of the house of JD 1, 3, and 5 have to be vacated, and under such circumstances, it is necessary to disconnect the electricity supply to the said house as a method of precaution. In view of report dated 24/11/2016, submitted by the court bailiff, the relief sought in the present two applications are sustainable. On perusal of the objection filed by the JD number 7, it is evident that there is no specific contention as to the applications filed by GPA holder of the decree holder. The respondent 7 has raised vague contentions which cannot be decided in the present applications. The question before this court at this stage is with regard to present applications. The contentions raised in the objections by JDR have already been decided by this court. The order sheet reveals that the predecessor of this court, through her order dated 5/11/2016, has issued delivery warrant with the assistance of jurisdictional police, including WPC, to hand over the vacant position to the decree holder. Delivery warrant was also issued on 10/8/7/2016, and the same was returned unexecuted. The objection filed by the JDR is only page filling exercise. and there is no real counter to decree. My lord, on that, it has not gone into the merits of the objections. Straight away, the order is passed. Now kindly come to page 34E, that is
No,
annexure
the
E.
delivery warrant was on 8/7/2016.
Yes,
You had no objection for that.
I had filed objection and matter went on.
Then what did
The-
you do
I-
when an order is passed? Where is that delivery, this order dated 8/7/2016? You find that also?
Yes, annexure F, my lord, page 35,
Page 35.
page 35.
So against this, have you preferred any, you have questioned this order?
Yes, my lord, then they kindly see page 35.
No, it has not been questioned, my lord. May I?
I will come
Yes.
to that.
So, no, let us have the facts clear.
Yes.
No, this order dated, where 8/7/2016.
Yes.
Where the delivery warrant was issued.
Yes.
Was not questioned.
Yes, because reason being, the delivery warrant is clear that, I mean, the special Tahsildar.
Let us see that delivery.
Yes, that begins at page 38. 38.
Yes.
Begins at page page 38. Then, may I read?
Please
From
read.
page 38. Yes. IA number 14 is filed seeking an order from this court to give assistance of the surveyor to the court, I mean, to identify the B schedule property, which is in occupation of the JDRs, which is shown in the plan prepared by the surveyor.
You're reading it 38 or somewhere else?
I think it is page 38, paragraph 1.
The present IA is filed.
And the, annexure F is the,
I'm looking at his paper.
no, annexure F
30?
is 38.
38.
Yes.
Yes.
38 may kindly be seen.
Yes.
IA number 14 is filed seeking an order from this court to give assistance of the surveyor to the court, I mean, to identify the B schedule property which is in occupation of the JDRs, which is shown in the plan prepared by the surveyor in the land tribunal proceedings. IA 15 is filed to direct the court, I mean, to identify the B schedule property with the half of the surveyor as per the plan prepared in the land tribunal proceeding. My lord, kindly note, my lord, the objection is the as per the plan prepared by the land tribunal surveyor, the order also speaks of it at the end of it. I will come to that. IA 16 is filed to direct the court, I mean, to deliver the vacant possession of the B schedule property by demolishing and removing the superstructures built by the JDRs with the mechanical devices at the cost of the JDRs. The above three IAs are seriously objected by the JDR number 7 by filing detailed objections. The gist of the objections filed by him to all the IAs is that B schedule property shown in the plaint and the decree passed by this court in the original suit is against some unidentifiable land. In fact, no such land is in existence. The decree holder should have got her property identified through the competent authority. Only after exhausting the remedy available to her, she can approach this court for delivery of the property which is decreed in her favor. Decree holder has hurriedly filed the suit before this court and obtained the decree. The B schedule property is also not measured even after filing of the suit through court process. The defendants in the suit were deprived of taking proper defense because of the tactics of the plaintiff, and this court was prevented from taking proper decision in the suit. Nowhere in the plaint it is stated as to where exactly 30 cents of land shown in the B schedule falls. The plaintiff did not have taken steps to identify her alleged 30 cents of land. In the present petition, if the decree holder is allowed to identify her 30 cents of land, that the JDS will be put to irreparable loss and hardship. In the suit, the decree holder has contended that only 30 cents of land is granted to by the land tribunal to the defendant, but the same is for respondent number 7 and her predecessor were granted. That can be skipped, madam, because that is on the merits of the tribunal order. Now kindly come to paragraph 8, reasons.
Yes.
The decree holder has filed this suit in the year 1999, which was decreed on 24/7/2007. As per the decree holder is entitled to get the vacant possession of the plaint B schedule property. In the suit, defendant number 4, JDR number 4 now dead, had filed his written statement which was adopted by defendants 1 to 3 and defendant number 5 to 7. The LRs of the JDR number 4 were brought on record. They have filed their objections to the main petition after the so-and-so. But my predecessor in office, after considering the materials on record, had rejected IA number 8, by which objection filed by them is not taken on record. Kindly skip that. Paragraph 9. As could be seen from the materials placed before me, it goes to show that the JDR 7 is fighting tooth and nail on the very same issue, which is already decided on by my predecessor in office. Even before this court, the very same point is argued. As such, to set the point in rest, some points are to be clarified, which are highlighted by the JDR number 7. As could be seen from the order sheet, it goes to show that the objection, after the objection filed by JDR number 4 to the main petition is rejected, as per order dated 28/3/2015, their counsel filed wakalat for so-and-so along with the earlier counsel. The order dated 28/3/2015 is not challenged by JDR number 4 before any high courts. As such, it goes to show that they are not aggrieved by the order of this court, but they have tried another way out by getting their advocate file wakalat for JDR 7 and are now trying to agitate their defense through JDR number 7. No doubt the defense of JDR 7 is also the same. Having not challenged the order of this court before any higher court, canvassing arguments on the very same defense on behalf of JDR 483 is not permissible. As such, now the only question remains to execute the decree of this court is that of JDR number 7. At the outset, it is to be noted that the JDR number 7 had adopted
Who is the petitioner?
JDR number 7. At the outset, it is to be noted that the JDR number 7 had adopted the written statement filed by defendant number 4 in the original suit. As could be seen from the judgment, it goes to show that in spite of giving opportunity to contest the case by cross-examining PW1 and by leading defendant's evidence, the JDR number 7 has not availed the said precious opportunity. Having not done the same in the present EP, JDR 7 cannot harp upon the decree passed by this court stating that opportunity was not offered to them by the court in the original suit. The only remedy that was available to the JDR number 7 is to prefer an appeal before the appellate court and to challenge the judgment and decree passed by this court. But the same is not done by him. As such, JDR number 7 is debarred from raising periferous objections when the decree of the court is being executed by due process of law. The bone of contention of JDR number 7 is that B schedule shown in the decree is not identifiable, and as such the decree is not executable. It is his contention that the decree holder in the present EP cannot take the assistive of the court or the court to identify the B schedule property. It is his contention that the surveyor cannot be appointed to identify the property in the execution petition. It is also his contention that the building or the superstructure in the property in possession of the JDR number 7 cannot be demolished by use of any machines as the property is not identifiable. It is his contention that the decree holder is trying to take forcible possession of the property, which is not the subject matter of the decree. Now it is necessary to go through the decree of this court. On perusal of the same, it goes to show that the B schedule property is described by the decree holder by showing proper boundaries. Now the court has to identify the set 30 cents within the boundary shown in the B schedule. The counsel for the JDR number 7 argued that the surveyor's plan referred to an IA number 14 is not produced before this court for scrutiny, nor the JDR is aware of the said survey plan. it is argued that there are 3 land tribunal orders. As such, JDR 7 is not aware as to which plan the decree holder is referring to. In that regard, it is necessary to go through the judgment dated so and so. The JDR 7 is relying upon order passed in TRI number so and so. Other than that, the order passed in TRI number 3065. When the judgment is read in between the lines, it makes it abundantly clear that the decree holder is referring to the plan sketch prepared in TRI number so and so. This plan is not placed before the court at all in the original site procedure. As the JDR number 7 was also the party to the said judgment, now cannot contend that he is not aware of the said plan or sketch. The report of the court,
So this order.
Yes, ma'am.
Whereby
Yes.
the court, is directed to execute the case decree.
Yes.
By as per the survey prepared by the surveyor in the Land Reforms Tribunal.
Yes.
In TRI number so and so, so and so.
Yes.
It is also by virtue of this order, it attained finality.
Yes.
That is not questioned.
That is not questioned.
Then what is the subsequent
yes,
order to this?
submission is only kindly come to page 46, madam.
Yes.
What
Yes,
is
I've
on
seen
the-
that.
Yes.
Para
The
16 may
special-
also be read. That is the para 16 of that order, concluding
I
portion.
shall read it. I shall read.
Where, para?
Page 45,
I've
para
seen.
16,
I've seen.
please.
Yes. Order. The IA number 14 to 16 filed by decree holder is allowed. Special Tahsildar, kindly see, is
Yes.
directed to give assistance of surveyor to the court, to identify the B schedule property.
As
Within-
per
Yes,
Land Reforms
yes,
Tribunal,
yes.
TRI
Shown
number.
in the execution petition, as per the plan sketch prepared by the surveyor in the land tribunal in TRI number so and so. Then
Thereafter, what has
execute.
happened?
Yes. in the-
Thereafter,
Thereafter, further court is directed to execute the delivery warrant by getting the buildings or superstructures put up by the JDS.
no, I'm saying after this order,
Yes.
what the court, has done.
No, court, kindly, this was on 37/2016.
This order is dated 28/3/2000.
This is 28, this is on 28/6/2016. Now.
No, this order is
8/7/16.
8/7/2016.
Thereafter, a survey is done, surveyor gives the report.
Where is the report of the surveyor?
On 9/8/2016,
Annexure E for a minute.
9/8?
9/8/16.
Where is that survey report?
Milord, on that, what has happened, my submission is this, that annexure E is the document which my learned friend has produced, which is a fabricated document, unfortunately. TCR was called for, the TCR is before the court. It shows different sense or the extent of the land is different in the original, which is in the court file, vis-a-vis what has been produced by my learned friend in the writ petition. Milord, may kindly take to annexure E.
Annexure E.
Where is this survey, this 9/8/2016, which is filed by him?
TCR is there, I can pass on a certificate copy, Milord.
That
No,
is at page.
His document, where
Annexure
is,
E, annexure E
Annexure
is the
E.
writ
page
petition
number?
file.
Page number 34. Page number 34.
Please pass on that. Put up. Give him a copy also. You have a copy.
It has the same.
Like he sketch yours.
It is in the TCR, which has been, which is before the court now.
What is the difference between these two?
Milord, the extent of the land, Milord, may kindly see, there is one portion where it is mentioned 0.06 acres. In the bottom portion, Milord, may I take third line? The first one refers to 0.14 acres. Next is 0.10 acres. Next is 0.06 as per the original one. Whereas it is shown as 0.16 in the sketch which has been produced by the plaintiff, by the petitioner before this.
Yes.
Yes.
The extent of the land itself has been increased to 40 cents instead of 30 cents. Sir.
Did you notice this?
My lord, this is.
I
it
think
was
TCR
not-
is also here. If you want to verify,
I
verify.
want to
pass over.
No,
Then,
my lord,
then-
may I make this submission, my lord? This point arose before my lord's predecessor, and only because of that reason the TC was.
Yes, seen that.
Yes, my lord.
I have not seen it.
No, what
This
I'm saying
reason-
is we'll pass over. Let him see this. We'll
Yes.
hear it in the afternoon.
And take instruction. If there is a falsification, then I will make my submission on that.
That 1 o'clock matter I've asked, no, all that.
Chamber, 1 o'clock submission matter. For 51.
Lord, I'm for the
Sunil
petitioner in
Shastri.
this my case, my lord. Petitioner should not get the leave, my lord. She is on business trip, my lord. That is the very reason she is unable to come. One more chance may be given for her to appear in chambers, my lord.
Why is it has
Serious
happened, Lordship?
inconvenience. There is no stay as of now today with regard to the MC also, my lord. And he never appeared till 8/2/2024. The matter is from 16/7/2022. I took a bailable warrant and then only they
No, no,
came.
first of all, they served it to the wrong address, so I have my own reservations. Lordship, it is being called twice to a chamber and we had come with the baby. And now luckily they noticed, they told me, and I am seriously objecting whether it has got any,
My only submission is, my lord, one more opportunity may be given.
No, why one more? Why, what, let us see what is happening.
Be present, my lord. She is actually meeting the child. The
2
child
weeks
is
time
very
is
happy,
granted to
my
so
lord.
and so. No, let us just see
those are all
what has happened,
irrelevant.
what has transpired. No, not about the earlier schedule. We appear for the wife.
Petitioner wants to settle the matter, my lord.
We appear for the father.
In principle, petitioner is ready for the divorce, my lord. Only
I
with
think
regard-
earlier the court has interacted, no?
The court has interacted with the daughter, the child, my lord.
child,
In
you
chambers.
had your intervention, we had given 4 weeks or 6 weeks of visitation. To the blink of an eye, we have served the orders to the T. Now, once apparently Lordship was not available, it got adjourned. Twice they have done.
Lord,
and
once the matter was not posted on.
So let us, anyhow, the girl has come. Let us see the girl. Let us talk to the girl. I'll ask her to come at 2 o'clock to the chambers. Is she now?
No, child, no, they notified me,
Prior, we have given the
they
intimation.
notified me that they will not come, so I told them not to come.
Prior intimation also was given because she was on a business trip.
What is happening in this overnight custodies and all?
What custody is ma'am?
No, an order is passed.
Yes.
So what has happened?
No, it's absolutely clear. Now they want to settle. You also wanted to refer the matter to the mediation, which we would want to take it with both hands. I only request that the orders are followed and in principle dates are also difficult.
What is the petitioner? What is she doing?
She's a software engineer.
Where is she now?
She's on a business trip with the work. On work only, she has gone for a business trip, my lord. She did not get leave. That is the very reason we intimated them very long back, my lord, that she will be not able to.
She's not a software engineer.
Not the dates. Dates for the in-chamber next available. 15th.
15/7.
This court has directed the parties to be present before this court. This court has directed the father, mother, and the child to be present for interaction in the chambers. It is submitted that mother is on a business trip. That's why she couldn't make it, which is objected with the counsel for the respondent, that they cannot seek adjournments like this as a final opportunity. Pose this matter on 15 at 5 o'clock in the evening in the chambers, or else the matter will be taken up the next day and appropriate orders will be passed. Yes.
Till number 20. N. Kumar for petitioner.
Hearing for respondent
Ramesh,
1 to 3.
yeah.
For petitioner, my lord, the petitioner being a different number 4, my lord, has filed an application seeking permission to file written statement, my lord, in a suit for declaration and injunction filed by the plaintiff, my lord, after lapse of 7 years, my lord, for assigning some reasons, my lord. This honorable court, my lord, has granted interim order directing me to deposit some 15,000 before the trial court, my lord, and directed the trial court to postpone the pronouncement judgment for 4 weeks, my lord. My submission before this court is.
It is like after, it is posted for judgment, you filed a.
During the cross-examination, I filed application, my lord. Thereafter, the proceedings were continued, my lord. And when the case is posted for judgment, this matter was heard before this honorable court and granted interim order, directed me to deposit 15,000 rupees, my lord. The submission is, my lord, I am ready to go on with the matter by day, my lord. Let my application may be allowed, my lord. I am ready to go on with the matter by day process, my lord.
No, why should the case be going on and why should, no, either it should be a stay on that day. And the court will go on with the matter and this will be kept pending. No, the judicial time of the judge is wasted there. And now again, we have to put the clock back.
No, my lord, my lord, I am the contesting defendant, my lord. Suit for
Correct.
declaration, again, my
Now,
property.
if this court feels that there is something has to be done, then it has to be stopped. Now, which year is the writ petition? 22 is the writ petition.
It has been
For
lifted.
2 years, the matter goes on.
My lord, it is lifted before this honorable court 3 times, my lord, but it not reached, my lord.
Listed when before this court?
My lord.
2022 matter in
Thereafter
2024.
also it is listed before 2 to 3 times, my lord. Due to paucity of time, it is not.
Correct. When is it listed? 22 writ petition in 24 only it is listed.
In the meantime, it is listed.
No, now you proceeded with the trial, everything goes on. Now
I
again,
am
now
not proceeded with the trial, my lord, because my written
you're saying that it is posted for judgment.
Posted for judgment, ex parte, my lord. You provided opportunity to the other defendants, my lord. There are number of defendants, my lord. Government also one of the defendants, my lord. My
So,
primary.
as on the date when you file this writ petition, what is the stage of the case?
Stage of the case is, my lord, I think arguments, my lord.
Defendant side arguments.
Arguments.
Arguments. Now everything is done. Now it is posted for judgment.
Vote for judgment since from 2022, my lord. The stage is going on, my lord.
It is posted for judgment and evidence is going on.
No, my lord. After affording the opportunity to lead a defense evidence to other defendants, thereafter the matter is posted for argument, my lord. Thereafter adjourned to judgment, my lord.
Why should this special treatment be given to this defendant? Let us see. Let us see. When is the suit filed?
Well, suit filed on 10/6/2014. 10/6/2014, madam. The defendant appeared before the trial court on 11/8/2014.
11/8/2014.
The defendant filed an application on 13/8/2021.
Application on?
30/38/2021.
Disputing the facts, my lord. I'm not disputing. I'm not
No,
disputing.
no, let us understand the admitted facts. 13/8/2021, he filed an application.
After lapse of 7 years.
Yes.
For filing additional written statement.
No, my lord, he has not filed a written statement before the trial court. When he had appeared, my lord, he is appearing in the year 2014, he has not filed an application. When the matter was posted for defendant side argument,
I think you
he
don't
has filed an
require, you don't
application.
deserve any concession. I can understand, I was under the impression that at least additional written statement you
No,
sought
no,
for.
no, no, no. It is a written statement. If he is not filed written statement, the trial court has not given to the.
My lord, I am ready to.
Let us see the reasons.
Please,
Please come to the order And come to the affidavit. What are the reasons stated by you for filing this application in the year 2021 in a suit of 2014?
Application, my lord, Annexure C, in page number 25.
Let him say. Yes. Please read your application, we'll see.
Application is Annexure C, my lord.
Yes, I'm looking at it.
Page number 25, my lord.
Yes.
Para number 2. I swear that the suit summons was served to me and I put my appearance through my advocate. After receiving suit summons and since then, I am attempting to search for certain document to file the return statement from my side and getting the record took time and it was not possible to get it soon and considerable time having been taken and the objection could not be filed in time and the delay is caused on my side and it was inevitable as I had misplaced my records pertaining to the suit of the property. The delay was not intentional and there is a good defense in this case. If the delay is not condoned and the return statement is not taken, I will be put to so and so, so that is the only contention. My lord, I am not disputing all these things, my lord. In spite of all this, my lord, my submission would be, my lord, fairly a time-bound order may be passed, my lord. I am ready to go on with the matter, my lord, day by day. My lord, one thing, another thing, my lord. The suit for declaration against my property, my lord, against my property.
That you should have realized in 2014 when you entered appearance.
Yes, the mistake has happened. my lord.
Courts can't come to a rescue of litigants like this. It is a pure abuse of process of law.
No, my lord, submission, my lord. I'm reeling down some Supreme Court judgments, my lord.
Yes, please place on.
Yes, sir. Tomorrow I will furnish, tomorrow. Right now I don't have.
The Supreme Court will not say, give the sweet time to the defendant for 8 years. That is not substantial justice. We have to balance the justice. We have to balance
Yes, I
both
do
to the
agree.
both the
I can relax
parties.
some judgment, my lord.
Tomorrow, pose this matter tomorrow. As at the top of the list.
Cell number 21, Suresh K. for petitioner.
Applying for respondent. Remember the plaintiff.
Right, Soma Reddy.
One submission. The petitioner has filed suit for declaration and injunction before the trial court. The injunction was granted. And in his favor, injunction was granted. And I had challenged it before the appellate court. And it was allowed and the injunction order was set aside. Now, my lords, I have instructions from the client that, my lords, he does not intend to alienate the property. Therefore, my lords, his petition may be allowed insofar as alienation is concerned.
What is the other order?
It is not to interfere in a peaceful position. I am in possession of the property. Even he consists to the fact that, my lords, if there is an order. We are in possession of the property.
How will he concede to that?
And,
That you are in possession of the property?
The trial,
Huh?
because the matter is set for trial now, before the lower court. That is it's set for trial, that can be decided before the trial, not here. In that case, my lordship may kindly hear the.
Huh?
My lordship may kindly hear the matter. Orders
And
be
that's what we have to hear it.
Please, Bandhan, my learned friend may kindly be.
Anyhow, how will he say that? He'll say that you are in possession of the property.
Lords, because fraud is.
Sought
taken
for a
place-
declaration injunction.
Lord, here what has happened is, my lord,
He didn't seek for recovery of possession.
what has
Please, my lords, I
happened
will argue
here
the
is,
matter, my lords. No, man, I do not have the papers, my lords. Let him finish the papers, day after tomorrow, Thursday, Friday, my lords, it's
Friday not possible. We'll have it on Tuesday.
Tuesday, please. Tomorrow.
Tomorrow. Anyway, he has to have the papers.
Tuesday, Tuesday. Provide a Xerox copy of the same. Tuesday, my lords, I will.
We'll have it Tuesday, doesn't matter. But we'll not grant any further time. Pose this matter on Tuesday at the request of the counsel for the respondent. No further time would be granted. Huh? Interim order, please look at the docket. If it is there, extend it to the next date of hearing.
Please.
Yes, next.
Cell number 23, 22. Yes, Ramamurthy for petitioner.
For respondents in this case, my lord, kindly pass over my lords.
Paso.
Cell number 28, 23.
This case appear for petition. Kindly pass on.
N. Raja.
My lord, one submission in this case, my lord. They have not furnished the proper copies, my lord. They without number illa, ಏನilla.
Kindly pass over.
It will, anyway, you have seen only number is the problem. He will give you the numbers.
I will give.
Properly number it and give it to you.
Kindly pass on.
Pass over. Yes.
Cell 24. 24. Gautam Raghunath.
I will file my objections also, lords, in this matter. Lords, so only, lords, I have sought for re-examination before the trial court, lord, which was allowed. Lords,
So let Mr. Gautam come in the afternoon. Required for your objections will then let you pass over.
Cell number 20.
Yes.
25 appear for the response.
Yes, you are ready?
Yes.
Yes. No, why you're going? You're ready with the matter? You sort of pass over. Yes, pass over.
Then number 26. Jairamaya.
For petition. Kindly press 2 days of time for amendment in the petition.
2016 petition, why should be permission be granted to you now? Who stopped you from amending it? We'll hear it, we'll look into it and we'll dismiss it. 2016
Can I have
petition.
2
can't be
days, the
kept
course
by-
of the day itself, we will do it 2 days ago.
Pose this matter tomorrow in the course of the day. The petitioner shall file the amended cause title, or else without further reference, the writ petition stands dismissed. Next,
Then number 27. Kenmukappa for
no,
petitioner.
it is already 1:30, no, dismissal matters will take it up after lunch. Yeah.
Kind permission, my lord. Serial number 50, interim order, my lord, there may be.
Serial number 15, if interim order is there, extended to the next.
Much
day.
obliged.
Just look at the docket.
ಎಲ್ಲ ಕಳ್ಸ್ಕೊಡ್ತೀವಿ. ಅದು ರಿಸರ್ವ್ ರಿಸರ್ವ್ ಒಂದು ರಿಸರ್ವ್ ಹಂಗೆ ಕೊಡ್ತಿದ್ದೀನಿ ರೆಡಿ ಇದೆ. ಆಗೋಯ್ತು.
ಇದ್ಯಾ?
ಬರ್ತಿದ್ದೀನಿ.
ಸರಿ. ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಇವ್ರು chamber ಹತ್ರ reserve.
ಇದೊಂದು 2 ನಾಳೆ 20 ಇನ್ನೊಂದು ಆಯ್ತು. 2 ಆದ್ರೆ ಮಾಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀರಾ?
3776 of 2020. 3776 of 2020.
Serial number 26.
Memo better.
Serial number 26. So, tomorrow course of the day,
ಯಾವ್ದು?
serial number 26.
ಅದೇ ಆಮೇಲೆ first date file ಮಾಡಿ sir. Without file ಇಂದ file ಮಾಡ್ದಲೇ
ಡಿಜಿಟಲ್ ಸೈನ್ ಇರ್ತದೆ.
ಮಾಡಿರ್ಬೇಕು ಇಲ್ಲಾಂದ್ರೆ ನಾನು
ಚೆಕ್ ಮಾಡ್ಬೋದು.
ಅರ್ಧ ಬರುತ್ತೆ. ಒಂದೇ ಮಾಡಿ. ಏನ್ ಮೆಮೋ ಅದ್ರ ಜೊತೆ ಹೋಗ್ಬಿಡ್ತಾ ಮೇಡಮ್ ಮೇಡಮ್ ಬರ್ದಿರೋದು ನಾನು ಏನು ನೋಡಿಲ್ಲ ಮೇಡಮ್ ನನ್ಗೆ ಅದು ರಿಸರ್ವ್ ಮ್ಯಾಟ್ರ್ ನೋಡಿ. ಹೌದೌದು ಇವ್ರದೊಂದು ಸ್ವಲ್ಪ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಮತ್ತೆ 20 ಇಲ್ಲೇ ಇದೆ 26 ಇಲ್ಲೇ ಇದೆ. ಇಲ್ಲೇ ಇದೆಯಾ? ಬಾಕಿದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಅಷ್ಟೇ ಇದೆರಡು ಡೇಟ್ ಇಲ್ಲ ಕೊಡ್ತಾರೆ ಸಿಗ್ನೇಚರ್.
ಮೇಡಮ್ 42 ವಿಡ್ರಾ ಆಗಿತ್ತಲ್ಲ? ವಿಡ್ರಾ
42 ಏನೇನು ಓ ಇದೆ ಯಾರು ಮೆನ್ಷನ್ ಇದೆಲ್ಲ
ಆಗುತ್ತೆ ಮೇಡಮ್. ಇಲ್ಲ ನಾನೇ ಬರ್ತೀನಿ. ನಾನೇ ಬರ್ತೀನಿ.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅದೇನೋ ಹೇಳಿದ್ರಲ್ವ ಇದ್ರಲ್ಲಿ ಏನು ಟಾಪ್ ಅಂದ್ರೆ ಅಷ್ಟೇ.
No, court officer.
ಬೋರ್ಡಿಗೆ ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ಬೇಕು.
What up, sir?
ಇಲ್ಲೇ ಇರ್ತಿದ್ರು ಈಚೆ ಕಣ್ಣು ನೋಡ ತಗೊಂಬಂದು.
Right? ಇಷ್ಟೊತ್ತಿಗೆ ಬೆಲೆ ಆಗಲ್ಲ.
ಅದೇನು ಒಂದೇ
ಐತಲ್ಲ ತಾಮ್ರ ಚೆನ್ನಾಗಿದೆ. ಬೇಗ ಮೂವ್ ಆಗ್ಬೇಕು. ಅವು ಅಣ್ಣ ತಮ್ಮ ಚಾಕು ತಮ್ಮರಲ್ಲಿ ಒಳ್ಳೆ ಒಳ್ಳೆ ಮಾನವ ತಂದಿದ್ದೀನಿ. ಡಬ್ಬಿ ಬಂದೈತೆ 3. ಬರ್ದಿದ್ದೀನಿ ಕುಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಸೀದಾ ಹೋಯ್ತಾವನಲ್ಲ, ಮಾತೆ ಕೇಳಲಿ ನನಗೆ. ಇಲ್ಲ ಆ ಕಡೆ ಅರ್ಧ ಹೊಡಿ, ಹೊಡಿತೀನಿ ಈ ಕಡಿತಾ ಅವನ್ ತಗೊಂಡ್ಬಿಡ್ತಾನೆ. ಹಂಗೆಲ್ಲ ಒಂದೇ ಯಾವ್ದಾರ ಒಂದು
ಬಾಟೆಲಿ ಏನಿರ್ತದೆ ಬಟ್ ಪ್ರಕಾರ ಕೊಡ್ಲೇಬೇಕು.
2 ಕೊಡ್ಬೇಕು. ಸರಿಯಾಗಿ ಕರ್ದಿದ್ದಾನೆ. ಯಾವ್ದು ತೆಚ್ಚಿಕ್ತೀನಿ ನೀರು ಸರಿ ಇಲ್ಲ ಜನ.
ಇವ್ರು ಯಾರು ಆಯ್ತು
ಇದರಲ್ಲಿ 2 ಪೀಸ್ ಬರುತ್ತೆ. ನಮ್ಗೆ
ಒಂದೊಂದು ಮಾಡ್ಬಿಡೋಣ ಈಗ. ಇಲ್ಲ ಐತಲ್ಲ ಐ ಪಟ್ರು ಬಂದಾಗ ಪಟ್ರು ಕೊಟ್ಟಾಯ್ತು ಇದ್ರಲ್ಲಿ ಅರ್ಧ
ವಾಟ ನೀನ್ ಇಟ್ಕೊಂಬಿಡು.
ಅರ್ಧ ನಾನು
ಅರ್ಧ ವಾಟ ಇನ್
ಅವ್ರಿಬ್ರು
ವಾಟ ಒಂದ್ ಅವ್ನಿಗೆ ಇವನಿಗೆ ಕೊಟ್ಬಿಡಾನು. ನನಗೆ ಸಿದ್ದು ವಾಟೆ ನನಗೆ ಏನಿಗೆ ಅಲ್ಲಿ ವಾಟ ಕೊಟ್ಟಿಲ್ಲ.
ವಾಪಸ್ ಕೊಡು.
ಮೊದ್ಲೇ ನ್ಯಾಯ ವಾಟಕ್ಕೆ ಯಾವ್ದೋ ವಾಟ ಕೊಡ್ತೀವಿ.
ಹೇಳು ಸರಿ ಇಲ್ಲ ಕಣ್ರಿ ಲಕ್ ಕೊಡ್ಬಿಟ್ರು ಕಣ್ರಿ ಅವರು. ಲಕ್ಕು ನಿಮ್ದು ನಾನು ಸುಮ್ಮನೆ
ತಗೊಳ್ಳೋ ಅದೇ ಕೊಡೋ. ಇದರಲ್ಲಿ ಅರ್ಧ ಪೈಸ್ ಬಿಟ್ಕೊಳೋ. ನಮ್ಮ ಮನೇಲಿ ಪಿಂಚಿನಲ್ಲಿ ವಾಟೆ ಇದ್ರಲ್ಲಿ ಅರ್ಧ ನಮ್ಮ
ನಂಗೆ ಕೂಡ ಹೊಟ್ಟೆ ಸೈಡಲ್ಲಿ ಇಲ್ವೇನಾ ಸೈಡಲ್ಲಿ ಇಲ್ವಾ ಪ್ಲೇಟ್ ಕೊಡ್ರಿ ಅವ್ರದ್ದು ಇಲ್ಲಿ ಮಾಡಿದ್ರಿ ಪ್ಲೇಟ್ ಯಾವ್ದಾರು ಒಂದು ಪ್ಲೇಟ್ ಇಲ್ಲಿ ದಯವಿಟ್ಟು ಬೇಡ ಅಂದ್ರೆ ಸಿದ್ದು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೆ ಈ ಮಗೆ ಬರದ ಬೇಡ ಅಂದ್ರೆ ಕಡ್ದು ಹಾಕ್ಬಿಟ್ಟು ಒಂದೇಲಿ ಈ ಭಟ್ರು ಮುಂದೆ ಗೊತ್ತಾಗ ಈಗ ಬರೀ ಬಿಟ್ರೆ
ತಿಂತಾನೆ ಸಿದ್ದು ತಿಂತಾನೆ ಅವ್ನು ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದು ಸುಂಗಿರ ಅನ್ನ ಸಾಂಬಾರ್ ಅನ್ನ ಸಾಂಬಾರ್
ಏನ್ ಸಾಂಬಾರು
ರಸಂ
ಸಾಂಬಾರ್ ಜಾಸ್ತಿ ಇದೆ ಮಾತ್ರ
ಜಾಸ್ತಿ ಐತೆ ಅಲ್ಲಿರೋದೇ ಸ್ವಲ್ಪ ಅನ್ನ ಮಾನನ್
ಇದು ನಿಂದೆ ಅದು
ಅವ್ನು ಬರತ್ತೇನಲ್ವಾ ತಿನ್ನೋಡ ಬರತ್ತ
ತಕೊಡ ಒಂದು ಅರ್ಧ ನೋಡಿ ಇಲ್ಲಿ
ಹಳೆ ಫುಲ್ ಡೇನು ಡಿಬಿನೇ ಸಿಂಗಲ್ ಏನಿಲ್ಲ ಅವನು ಏನು ಫುಲ್ ಡೇ ಡಿಬಿ ಅಂತ ಏನೋ ಅಪ್ಲೈ ಅದು ಇದು ಅಂದ್ರೆ ಇನ್ಚಾರ್ಜ್ ಹಾಕಿದ್ದೀನಿ ಮತ್ತೆ ಒಂದು ಮೇಡಮ್ ಸಂಜೆನೆ ಹೋಗ್ತಾರೆ ಡಿಬಿ ಕಡೆ ಒಬ್ರು ಇರ್ಬೇಕು ಸಿಂಗಲ್ ಕಡೆ ಒಬ್ರು ಇರ್ಬೇಕು ಅಂತ
ನೀನು ಬದಲು ಮಾಡ
ಕಾನೂನು ಇದೆ ಇದೆ
ಒಂದು ಅವ್ರ ಮನೇಲಿ ಅವರೆಲ್ಲ ಅವ್ರ ಮನೇಲಿ
ನಾನು ಅವತ್ತಿಂದ ಅನಿತಾದಲ್ಲಿ ಇದ್ದೀವಿ.
ಮುಂದೆ ಬಿಚ್ಚಬೇಕು.
ಫೋನ್ ಮಾಡಿದ್ರೆ ಬರ್ತೀನಿ.
ಒಂದು ಇಟ್ಟಪ್ಪಿಲ್ಲ ಇದು. ಒಂದೇ ನೋಡ್ಕೊಬಿಡ.
ಜನ ಇದ್ದಿದ್ದು 5 ಜನಕ್ಕೆ ಬಂದು ಮುಟ್ಟುವಲ್ಲ ಕಡೆಗೆ.
12 ಜನ ಇದ್ದೀವಿ ನಾವು.
ಟೇಬಲ್ ಹಾಕೋದ ಕೊಟ್ಟಲ್ಲ ಯಾವ್ದು
ಅಲ್ಲಿ ಅಂಟುಗಳಲ್ವೇ. 5 ಜನ ಬರ್ತಾ ಇದ್ದೇವಲ್ಲ.
ಅಲ್ಲಿ ಕೊಟ್ಟು
ನಮ್ದೇ ಒಂಥರ ಆಗ್ಬೇಕೈತೆ. ಇಲ್ಲ
ತೀರ್ಥ ಕೊಡೋರು ಅರ್ಥ ಇರೋದು. ಎಂಟು ಮಂದಿ ಅವರಾಗ ಮಾಡ್ಕೊಂಡಿದ್ರು.
ಯಾಕೋ ಸತೀಶನೂ ಗೊತ್ತಾಯಿಲ್ಲ. ಇವರು
ಕ್ಲೀನ್ ಆಗಿದ್ರೆ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಗೊತ್ತಾಗಬೇಕು ಏನ್ ಮಾಡಿದ್ರೆ ಕ್ಲೀನೆಸ್ ತಾನೆ.
ಬೇಡ ಚಟ್ನಿ ಬಾ
ಕಡೆಗೆ ಬೇರೆ ಆಗ್ತಾ ಇದೆ.
ಆಫ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಬಂದ ತಕ್ಷಣ ನಾವೇ ಏನ್ರಲ್ಲಿ ಪಲಾವಲ್ಲಿ
ಇಲ್ಲಿ ಪಲಾವ್ ತರ್ಬಾರ್ದಲ್ಲ ಮೇಲೆ.
ಬರುತ್ತೆ.
ಇದ್ದು ಇಲ್ಲಿ ಪಲಾವು ಮೇಲೆ ತರಬಾರ್ದು.
ಬಿಟ್ರೆ
ಏನ ಮರ
ಎಂತದು ನಿಮ್ದು ರಸಮ ರಸಮ್ ಲಾಸ್ಟ್ ಇಷ್ಟೆಷ್ಟು ತಣ್ಣಗೆ ಅಷ್ಟು ಯಾವ ರಸಮ್ ಕಲ್ಸಲ್ಲ. ಬೇಗ ಹೋಗ್ತಾರೆ ಅಂತ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ.
ನಾವು ತಪ್ಪನೆ ಮಾಡೋದಲ್ಲ
ನಮ್ ಕಮ್ಮಿ ಯಾಕೆ ನಮ್ಗೆ
ನಿನ್ಗೇನು ಕೆಲಸ ಇಲ್ವಲ್ಲ ಬಿಡ.
ಅಲ್ಲ ಅವನಿಗೆ ಹೇಳ್ತದೆ.
₹1,000 ಕಳ್ಸ ಹಂಗೆ.
₹1,000 ಬೇರೆ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಅವನೇ ನನ್ಗೆ 1,000 ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
8,000 ಕೊಟ್ಟಿದ್ನಲ್ಲ ಹೋದ್ ಸರಿ collection ಆಗಿದೆ. 10,000 ಟೋಟಲ್.
ಮಾತಾಡ್ವಾ? ಯಾರು ಇಸ್ಕೊಂಡ್ರು?
ಯಾರು ಇಸ್ಕೊಂಡ್ರು ಅಂತ.
ಯಾರು ಇಸ್ಕೊಂಡ್ರಿ? ಅದು ನಮ್ಗೆ ಅಂದ್ರೆ ಈಗ ಅಷ್ಟೇ.
ಇನ್ನೊಬ್ರು ಜನಕ್ಕೆ
ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ಮಗನ ಏನು ಅಷ್ಟೊಂದು ತಿನ್ನಲ್ಲ.
ಲೈನು
ಈ ಮಟ್ಟಿಗೆ
ಸದಾ ಇವೆಲ್ಲ ಮನ್ಸಲ್ಲಿ ಇಟ್ಕೊಳ್ಳೋ.
ಇಟ್ಕೊಂಡಿದೀನಿ.
ಇದು ಒಂದಲ್ಲ ಅಂತ ಕೊಟ್ಬಿಡ್ತೀನಿ ಸದಾ. ಈ ಮಾತು ನಿಮ್ಗೆ ಆಗ್ತದೆ. ಇನ್ಮೇಲೆ ಅಷ್ಟು ಇದೆ ಅಂತ.
ಇನ್ಯಾರು ಕೊಡ್ಬೇಕು ನೋಡು. ಯಾವ ಮೊದಲು ಇನ್ಯಾರು ಕೊಡ್ಬೇಕಾ?
ಬರೀಕಿಲ್ಲ ಅನ್ಕೊಂಡೆ ಇದ್ದು ಬರೀಕಿಲ್ಲ ಅಂತ ಕೊಡಕ್ಕಾಗ
ನೋಡ್ರಿ ಮತ್ತೆ ತಾನೆ
ಭರತ ಸಾರ್ ಹಾಕತಾವ್ ನೋಡಲ್ಲೇ.
ಹೇಳು
ಇನ್ನ ಮಾತ್ರ ಬೇಡ.
ಬೇರೆ ಯಾರನ್ನಾರ ಹಾಕೊಂಡು
ಮಂಜು ಬಂದ.
ಅವನು ಅಲ್ಲಿಗೆ ಬರ್ತೈತೆ.
ಮತ್ತೊಂದು ಹೆಂಗಿರೋದು
ನಿಮ್ಮದಾ ಬೆಟ್ರ್ ಮಾಡಿ ಒಂದು ಸಲ ಯಾಕೆ ಕ್ಯಾನ್ಸಲ್ ಹುಳ ಹುಳ ಹೊಡಿದಲ್ಲ ಸ್ಪೆಷಲ್ ಇದ್ದಂಗೆ ಐತಲ್ಲ ಗುರು. ನಾನು ಮಾತಾಡ್ತೀನಿ ನಾನು
ಚಾ ಕೊಡಿಲ್ಲ
ಅದು ಗೊತ್ತಾಯ್ತಾ?
ಮಂಜು ಹೇಳ್ತಾರೆ ಸ್ಟೋರಿ
ಇಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ರು ಪೇಪರ್ ಮುಂದೆ ಇಡ್ತಾ. ಸಿದ್ದು
ನೆಕ್ಸ್ಟ್ ಮಂತ್ 3 ದಿನ ರಜಾ ಇದೆ.
ಯಾವಾಗ?
ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಮಂಡೇ.
ಇದು 15th
ಹೇಳ್ಬೇಕು ಅವಾಗ ಬರೋದು ನಿಮ್ಮನಿಗೆ ಪರಿಚಯ ಬಿಡಿ. ಎಷ್ಟು ಜನ ಇದ್ರೆ ಪಾಯಿಂಟ್ ಇವಾಗ
ಅಲ್ಲ ನಮ್ಗೆ ಇನ್ನೂ ಅಡ್ವಾಂಟೇಜ್ ಸೋಮವಾರ ರಜೆ ಇರೋ ಬಂದು ಆರಾಮಾಗಿ ರೆಸ್ಟ್ ಮಾಡಿ ಡ್ಯೂಟಿ ಭಾನುವಾರ ಮಧ್ಯರಾತ್ರಿ
ಇವಾಗ ನೀವು 4-5 ಜನ ರೆಡಿ ಇರ್ತೀರಾ.
ಸೋಮವಾರ ರಜೆ ಇರುತ್ತಲ್ವಾ ಅಟ್ಲೀಸ್ಟ್ ಊರಿಗೆ ನೀವೆಲ್ಲ ಎಲ್ಲರೂ ಹೋಗಿ ಬಂದು
ಬರೋ ಪಾಯಿಂಟ್ ಬರೋದು. ಈಗ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಈಗ ನೀವೆಲ್ಲ ರೆಡಿ ಆಗಿಬಿಟ್ಟಿದ್ದೀರಾ. ನಾನು ಹಂಗಾದ್ರೆ ಇದು ಬರಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದೇನ ಅದು ಕ್ಯಾನ್ಸಲ್
ಅವಾಗೇನ್
ದುಡ್ಡೇ cancel.
ದುಡ್ಡುದು ಮತ್ತೆ ಅವತ್ತು
ನಿಮ್ದು ಅಕಸ್ಮಾತ್ ಹಂಗೆ ನೀವು ಮಾತಾಡ್ಬಾರ್ದಾದ್ರೆ ನಿಮ್ದು ಹಂಗೆ ಆಗ್ಬೋದು ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಅವಾಗೇನ್ ಮಾಡ್ತೀರಾ ಪಾಯಿಂಟ್
ಅರ್ಧ ದುಡ್ಡು ಕೊಡೋದು.
50% ಅಮೌಂಟ್
ಆ ಥರ ಪ್ಲಾನ್ ಮಾಡ್ಬೇಕು. ಅವಾಗ ಸಮಸ್ಯೆ ಇರುತ್ತೆ.
ಮೆಡಿಕಲ್
ನಾಳೆ ಪ್ಲಾನ್ ಹಾಕಿದಿರಪ್ಪ ನಾವು ಬರೋಣ ಅಂದ್ಬಿಟ್ಟು ನಾನೇ
ಇನ್ನೇನ್ ರೀಸನ್ ಬೇಕು.
ಈಗ ಗಂಗಾ ಇಲ್ಲೇ ನಮ್ ಸಾಹೇಬ್ರು ನಾಳೆ
ಏನೋ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ರು ಗಂಗಾಧರ ಅವತಾರ ತಗೊಂಡಿದ್ದೀವಲ್ಲ.
ಟೇಪ್ ಹಿಡಿಯೋದು ಬಂಡ್ಲು ಅವೆಲ್ಲ
ಇನ್ನೇನ್ ರೀಸನ್ ಒಂದೇ ಮೆಡಿಕಲ್
ಏನಾರ ಆಗ್ಲಿ ನಾನು ಬಂದೇ ಬರ್ತೀನಿ.
3 ದಿನ ರಜೆ ಇರುತ್ತಲ್ಲ ನೆನ್ಸಿ ಬಿಡಲ್ಲ
ಅವೆಲ್ಲ ಲೆಕ್ಕನೇ ಇಲ್ಲ. ಅವೆಲ್ಲ 50%
ಅದು ಫಸ್ಟ್ ನೀವು 15 ದಿನ ಮುಂಚೆನೆ ಒಂದು ಇದೆ
ಒಂದ್ ತಗೊಂಡ್ರೆ ಒಂದ್ ಫ್ರೀ, ಒಂದ್ ತಗೊಂಡ್ರೆ ಒಂದ್ ಫ್ರೀ.
ಇದು ಏನ್ ಗೊತ್ತಾ ಪ್ರಾಬ್ಲಮ್ ಬಂದೇ ಬರ್ತಾ
ಇನ್ನು ಒಳ್ಳೆದಿದ್ದಾನೆ
ಏನದು ನಿಂದು ಪ್ರಾಬ್ಲಮ್ ಇರ್ತೀಯ, ನೀನು ಬರಲ್ಲ, ಊರಿಗೆ ಹೋಗ್ಬೇಕು 3 ದಿನ ಅಂತ ಹೇಳ್ತೀಯ. ಇದನ್ನ ಟಿಕೆಟ್ ಹೋಗಿದ್ದ 15 ದಿನದ ಮುಂಚೆನೆ
ಮದುವೆ ಪೂರ್ತಿ ಏನು ಕೊಡಂಗಿಲ್ಲ.
ಅಕ್ಕಿ ಹೇಳ್ತಾರೆ ಅವರು
50% ಅಲ್ಲ, ನಿಂದು ಫುಲ್.
ಕೇಳು
ನಿಂದು ಫುಲ್ಲು.
ಇನ್ನೇನ್ ರೀಸನ್ ಸಿಕ್ಕಿಲ್ವಾ ಫುಲ್
ಅದ್ ಬಗ್ಗೆ ಅಮೌಂಟ್ ಇಟ್ಕೊಂಡಿರೋರು
ಎಲ್ರೂ ಇದ್ರಲ್ಲ
ಯಾಕೆ ಕೇಳೋ
ಪ್ರಾಬ್ಲಮ್ ಇದ್ದೇ ಇರುತ್ತೆ.
ಮಂಜು ಯಾಕೆ ಕೇಳೋನು ಅವ್ನು ಫುಲ್ಲು ಅಕೌಂಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿರ್ತಾನ.
ಬೇಕಲ್ಲ ಮತ್ತೆ
ನೀವು ದುಡ್ಡು ಕೊಡದಲ್ಲೇ ಕನ್ಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕಂದ್ರೆ ಆ ತರ ಆಟ ಬರ್ತದೆ.
ಈಗ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಲ್ಲ
ಕೊಟ್ಬಿಟ್ಟಿದೀವಲ್ಲ ಬರ್ಬೇಕು ಅಂತ
ನಾನು ಬದ್ದೂರಲ್ಲಿ ಬಂದು ಪಿಕಪ್ ಮಾಡ್ಕೊಳಕ್ಕೆ
ಎಲ್ಲೋ ಒಂದ್ ಅರ್ಧ ಗಂಟೆ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡಿರ್ತೀನಿ.
ಮೈಸೂರು ಕಡೆ ಹಾಕ್ಬಾರ್ದು,
ಈ ಕಡೆ ಹೊಡ್ಬೋದು. ಏರ್ಪೋರ್ಟ್ ಕಡೆಗೆ ಬಂದ್ಬಿಡು ಅನ್ಬೇಕು.
ಜಿನಿಯನ್ ಕಡೆ ಹಾಕ್ಬೇಕು.
ಒಟ್ಟಾಗ ಒಂದ್ 2
ಮೈಸೂರು ಕಡೆನೇ ಬೇಡ ಗುರು, ಮೈಸೂರು ಕಡೆನೇ ಬೇಡ. ನಾವೆಲ್ಲ ಮೈಸೂರು ಕಡೆ ನೋಡ್ಬಿಟ್ಟಿದ್ದೀವಿ, ಇನ್ನು ಊಟಿ ನೋಡಿಲ್ಲ ನಾವೆಲ್ಲ.
ಇನ್ನು 2ನೇ ತಿಂಗಳು
ಆಗ್ಲೇ ಇವಾಗ ಪ್ಲಾನಿಂಗ್ ಹೆಂಗೆ ಅಂತ
ಈಗ 20,000 ರೂಪಾಯಿ ಇಟ್ಕೊಂಡಲೆ 10 ಜನ ಕೊಟ್ರೆ 11 ಜನ ಕೊಟ್ಟಿರೋದು.
20,000 ಒಂದು ಗಾಡಿ ಬಾಡಿಗೆ
ನೆಕ್ಸ್ಟ್ ಮಂತ್ 3 ತಿಂಗಳು ಆಯ್ತದಲ್ಲ.
ಏನಕ್ಕೂ ಆಗಲ್ಲ, ಗಾಡಿ ಬಾಡಿಗೆ
ಗಾಡಿ ಫ್ರೀಯಾಗಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀವಿ ಸುಮ್ಗಿರಪ್ಪ. ನಿಮ್ಗೆ ಯಾತಕ್ಕೆ ನಾವು ಎಲ್ಲೋ ಗಾಡಿ ಫ್ರೀಯಾಗಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀವಿ, ಡೀಸೆಲ್ ಹಾಕ್ಬಿಟ್ಟು.
ಅಲ್ಲೇ ಬಿಟ್ಟು ಬಂದಿದ್ದೀನಿ, ಇತ್ತು ಅಲ್ಲೇ ನೋಡ್ದೆ ನಾನು.
ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದು ನಾನು ನೋಡಿ, ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಕೇಳ್ತದ.
ನಿಮ್ ಜೊತೆ ಭಟ್ರ ಮನೆ ಅಣ್ಣನ ಮನೆ
ಈ ನಮ್ಮ ಶೆಟ್ಕನ್ ಒಂದು PDO ಆಫೀಸರ್ ಅವ್ರಿಗೆ ಗಿಫ್ಟ್ ಯಾರೋ ಕೊಟ್ಟಿ ತಂದ್ಕೊಟ್ಟಿದ್ರು. ನಾನು ಹೆಂಡತಿ ಹೋಗಿದ್ಲಲ್ಲ ಕಾರಣ ಹೊಡ್ಕೊಳ್ಸಿ ಒಂದು 50 ಮಾನ ಕೊಟ್ಟ.
50 ಏನೇ ಮಾಡ್ತೀವಿ ಕೊಡ್ದಾಗಲ್ ಬಿಡ್ರಿ,
ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟ ಸುಮಾರು
50 ಆಮೇಲೆ 30 ಬಂದ
ಮನೆಗೆ ತಗೊಂಡು ಕೊಟ್ಟ.
50 ಬಂದ
ನಿನ್ನೆ ಬಂದು ಒಂದು 10
ವೈಟ್
ದೂರ ಮಾಡ್ಲಾ ಹತ್ರ ಮಾಡ್ಲಾ?
ಡಿಸೈಡ್ ಆಗಲ್ಲ. ಭಾನುವಾರ.
ಆಕಳ ಏನಾಗ ಅದ್ರ ಮುಚ್ಚಳ ಏನಾಯ್ತು?
ನಮ್ಗೆ ನಿನ್ನ ಒಂದೇ
ಕೆಲಸ ಕಡೆ ಬಿಡ ಆಗಲ್ಲ ಬಿಡ. ಆ ಮೂಲೆಯಲ್ಲಿ ಈ ಮೂಲೆಯಲ್ಲಿ ಕೆಲಸ ಕಡೆ ಬಿಡ ಆಗಲ್ಲ. ನನ್ನ ಜೊತೆ ಹೋದ್ರೆ 2,000 ರೂಪಾಯಿ ಸಿಗ್ತದೆ. ಅಲ್ಲಿ 2 ಹಾಕೊಂಡ ತಗೋ ಟೋಕನ್. ಮತ್ತೆ ಬರ್ಬೇಕು ಮತ್ತೆ ಕರೆದ್ಮೇಲೆ. ಇಲ್ಲ ನನಗೆ ದುಡ್ಡು ಲಾಸ್ ಆಗ್ಬಿಡ್ತದೆ. ದುಡ್ಡು ಬರಲ್ಲ ಅಂದ್ರೆ ಅಮಾವಾಸ್ಯೆ 5ನೇ ತಾರೀಕು ಶುಕ್ರವಾರ. ಯಾಕೆ ನಾನು ಚೆನ್ನಾಗಿಲ್ಲ. ಎಲ್ಲ ಒಂದೇ ಶ್ರಾವಣದಲ್ಲಿ ಮನೆಯಲ್ಲ ಮದುವೆ ನಾನು ಶ್ರಾವಣದಲ್ಲಿ ತಿನ್ನಲ್ಲ. ಅದೇ ನಿಮ್ ಜೊತೆ ಬರ್ತೀವಲ್ಲ ತಿಂತೀನಿ. ನಾನು ಯಾವತ್ತೂ ಬಿಡಲ್ಲ. ಕೊಟ್ಮೇಲೆ ಯಾವತ್ತೂ ಬಿಡಲ್ಲ. ಏನ್ ಮಾಡಿದ್ದೀರಾ ಗಂಗಾಧರ? ಗಂಗಾಧರ ಫೋನ್ ಮಾಡಿದ್ದ? ಆಯ್ತು ಮಾಡಾಯ್ತಲ್ಲ. ಆಯ್ತಾ ದುಡ್ಡು ಮಾಡ್ದ ಕಳ್ಸ್ಬಿಟ್ಟ? ನಾನೇ ಕಳ್ಸಿಲ್ಲ ಕಣ ಇನ್ನು. ನಮ್ದು ಕ್ಯಾಶ್ ಟು ಕ್ಯಾಶ್ ನಮ್ದು ಇನ್ನು ಕಳ್ಸಿಲ್ಲ ಬಿಡು ನೀನು. ಕಳ್ಸಿಲ್ಲ. ಫೋನ್ ಪೇ ನೆನ್ನೆ ಆಗ್ಬೋದು. ನೆನ್ನೆ ಗೂಗಲ್ ಪೇ ಫೋನ್ ಪೇ ಇದೆ ನಂಬರ್. ಎಷ್ಟು ದಿವಸ ಅಂತ ಹೇಳ? 15 ಸಾವಿರ 20 ದಿನ ಬರುತ್ತೆ. ಫುಲ್ ಬರುತ್ತೆ. ಆಚೆ ಬಂದ್ರೆ ಆಗ್ತಾ ಇಲ್ಲ. ಕೊಟ್ಟಿರೋ ರೂಪಾಯಿ ತಿಂಡಿ ತಿನ್ಬಂದ್ರೆ ಲಾಸ್ ಅವನಿಗೆ ತಿಂತಾನೆ. ಈಗ ಬಟ್ಟೆ ಏನ್ ತಿಂತಾನೆ? ಬಟ್ಟೆ ತಿನ್ನೋದೇ ಬೇಡ. ವೆಜ್ಜೆಲ್ಲ ಚೆನ್ನಾಗಿರೋ ತಿನ್ಕೊ. ಪನ್ನೀರು ಅವು ಇವು ಹಾಳು ಬಟರ್ ಕೊಂಚ ಹುಡುಗರು ಚೆನ್ನಾಗಿರ್ಲಿ ಬಿಡ. ಏನಾದ್ರು ಹುಡುಗರು ಚೆನ್ನಾಗಿರ್ಲಿ ಅಲ್ಲ ನಾ ಮಂಜ ಹುಡುಗರು ಚೆನ್ನಾಗಿರ್ಲಿ. 38 ಸಾವಿರನಾ? 38 ಸಾವಿರನಾ? ಬೇಡ ಬಿಡು. ಕಳ್ದ್ರು ಹೋಗಲ್ಲ. ನಿಮ್ ಬಗ್ಗೆ ಗೊತ್ತು ಬಿಡ, ನಿಮ್ ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನೇ ಹಾಕಿದ್ದೀನಿ. ಆದ್ರೂ ಅಲ್ಲಿ ಬರ್ತದೆ. ನೀನೊಂದು ಬರ್ತದೆ.
ಅದ ಮ್ಯೂಟ್ ಆಯ್ತಲ್ಲ? ಹ? ಹ. ಅದೇ ಒಂದ್ ತೆಗೆದ್ಬಿಡು ಲಿಸ್ಟ್. ಯಾಕಂದ್ರೆ ಇವತ್ತು ರಿಮೈನಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡ್ಬೇಡಿ. ಈ ವಾರ ಇಲ್ಲ. ಹಾ? ಫ್ರೈಡೇಗೆ 20 ಮಾಡ್ತವೆ. ಮಂಡೇ ಕೊಡ್ಬೋದು ಅಷ್ಟೇ. ಮಂಡೇ 42 ಮಾಡ್ತಿದೆ. ಏನು ನೋಡ್ಕೊಳ್ಳೋದೇ ಇಲ್ಲ, ಹೇಳ್ದಲ್ಲ ಈಗ ಅದೊಂದು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ಗೆ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಆ ಪೋಸ್ಟಲ್ ಕಳಿಸ್ಬಿಟ್ಟು ಅದು ಅಡ್ರೆಸ್ ಇನ್ಸಫಿಷಿಯೆಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ವಾಪಸ್ ಬಂದಿದೆ. ಮೀಡಿಯೇಷನ್ನೇ ಆಗಿಲ್ಲ ಅದು. ಅದೇ ಇವತ್ತು ಬೆಳಗ್ಗೆ ಆರ್ಡರ್ ಆಯ್ತು ನೋಡಿ. ಅದೇ ನಾನು ಆಮೇಲೆ ಹೇಳಿದೆ, ನೀವು ಇನ್ನೊಂದು ಆಫೀಸ್ ಕೊಂಡು ಫಸ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಆರ್ಡರ್ ತಗೊಳ್ಳಿ ಅಂತ. ಅದು ಆಕ್ಚುಲಿ ದಟ್ ಕಮಿಟಿ ಇದಾದಾಗ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋ ಮ್ಯಾಟರ್ ಏನು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೊಡಲ್ಲ. ಅದು ಏನ್ ಮಾಡ್ತಿರ್ತಾರೋ ಅಪ್ಪ ಕೇಸ್ ನನ್ನಂತೂ ನಿಜವಾಗ್ಲೂ ನಾನು ಸಜೆಷನ್ ಕೊಡ್ಬೇಕು ಅನ್ಕೊಂಡಿದ್ದೀನಿ ಮೀಟಿಂಗ್ ಕಂಡಕ್ಟ್ ಅಲ್ಲಿ. ಮೀಟಿಂಗ್ ಅಲ್ಲ. ಅದು ಯಾವ್ದೋ ಮ್ಯಾಟರ್ ಆರ್ ಜೆ ಚೇಂಬರ್ ಅಂತ ಹೇಳಿದ್ರು. ಸರಿ, ನಾನು ಹೇಳ್ದೆ ಅದು ಕೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಮ್ಯಾಟರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ, ಸಂಜೆ ಫೋನ್ ಮಾಡಿದಾಗ ಹೇಳ್ತಾಳೆ ಆರ್.ಜೆ ಅಲ್ಲ ಆರ್.ಜೆ ಚೇಂಬರ್. ನಿಮಗೆ ಮಿಸ್ಕಮ್ಯುನಿಕೇಶನ್ಸ್. ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ದೆ, ನಿಮ್ಗೆ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದ್ರು ವಿ ಗೋ ಟು ದ PS ಅಂಡ್ ಸೀಕ್ ದೇರ್. ಬೆಳಗ್ಗೆಯಿಂದ ಹೇಳ್ತಿದ್ದೆ. ಈಗ ನಾವು ಅವ್ರು ಏನ್ ಹೇಳಿರ್ತಾರೋ ಅದನ್ನ ನಾನು ಹೇಳಿದ್ದೆ. ಅದು ಸಂಜೆಗೆ ಬೇರೆ ಆಗ್ಬಿಟ್ಟ. ನಾಲ್ಕಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 7, ಆಮೇಲೆ 19, 22 ಇಂದ ನೆಕ್ಸ್ಟ್ ಫುಲ್ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ಸ್. ಯಾವ್ದು ಗ್ರೀನ್ ಪೊಕೆಟ್ ಆರ್ಡರ್ ಆಯ್ತು. ಅದು ಅದೇ ರೀಕನ್ಸ್ಟ್ರಕ್ಟ್. ಹಾ ಅಷ್ಟೇ. 73 ಓದ್ಬಿಟ್ಟು. 73 ಅಲ್ಲ, 73 ಅಲ್ಲ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅರ್ಜೆಂಟ್. ಮೇಘಾಗಿದೆ. ಹೌದಾ? 18/7. Yes. After that you keep it there. ಪಾಸ್ ಓವರ್ ನಿಮ್ದು ಫಾಸ್ಟ್ ಓವರ್ ಅಲ್ಲಿ ಇದೆಯಾ ಸರ್? ಎಷ್ಟು ಸೀರಿಯಲ್? ಹಾ ಕರಿತೀನಿ. ಅದೇ ಇವಾಗ ಬಂದ ತಕ್ಷಣ ಕೇಳ್ತೀನಿ.
Continuation matter.
One submission in this case.
There will be 23 minutes. I represent the petitioner.
I am representing the respondent.
My amendment is suggesting it should be referred to VMC Bangalore. instead of-
What has happened to 23?
Matrimonial cases.
Matrimonial.
Huh?
Matrimonial dispute.
No. What has happened? It is
Password.
passed over. Both the parties submit that the matter may be referred to the mediation. Accordingly, both the parties shall appear before the Bangalore Mediation Center on 18th.
Fifth.
By 3 o'clock.
Huh?
Before
For VMC.
Which day?
Any date, relax.
18th at 3 p.m. This is the,
in early release.
huh?
In early agbitre.
Early,
15th,
apply.
Register Judicial is directed to communicate the same. Yes.
Much.
Cell number 7, fast over matter. Gowda.
How many passovers? Who appear for the respondent?
Lokesh Babu, M for R4. Murali N. Lokesh Babu.
Who appears for the respondent?
Lokesh Babu.
Who appears for the respondent?
Murali N.
What is impugned in this writ petition?
Order 6 Rule 17.
Oh.
Application is filed by the defendant to delete certain portions, including the prayer, and also himself as one of the parties.
Hmm.
That application is allowed. Therefore, against that order, the plaintiff has come up before my.
I think the respondent is not there. Tomorrow under part third, we'll have it. Counsel for the petitioner is present, heard in part, no representation on behalf of the respondent. Post this matter tomorrow.
Please, please.
Yes.
Cell number 19. Chandranath Tariga.
Should kindly pass over. Senior is held up in one parted matter. He'll be available after 3, my lordship, 3 o'clock. Kindly pass over, my lordship.
Call this matter at 3 o'clock, no further accommodation. 3 o'clock. Yes.
Cell number 22. S. Rammurthy, for petitioner.
For respondents, my lord, senior is held up in court hall 19.
I am for the petitioner, my lord.
My lords.
I am ready.
Senior is in court hall 19, my lords, he's coming.
Who asked for a password in the morning?
Respondent itself.
And then what will happen to him? He'll be waiting for the whole day for you.
Apologies, my lords.
This also at 3 o'clock. 3 o'clock.
Milord?
3 o'clock.
No, another date may kindly be given, Milord.
My lords, we have moved the matter, my lords.
Because they
Only
moved
due to
it.
Inconvenience.
When you
that's
moved
caused.
it, you should be here.
They moved it.
It is, my lords.
3 o'clock. If they don't turn up by 3 o'clock, we'll post it on some other day.
But other matters are there, Milord. Lot of matters are there.
For whom?
In the court hall.
Oh, this matter, earlier part, again passed over matter, this and this both will be called at 3 o'clock.
3 o'clock. again.
Yes.
Cell number 24. Gautam Raghunath.
Petition. Apologies, I cannot be in the first one, my lords.
What is this petition about?
My lords, now what happens is,
Where is the counsel for the respondent? Morning he was here. Yes. What is the impugned order?
please, impugned order is it, my lords? Page number 21 to 24, my lords.
20?
Page number 21 to 24. My lords, after I conclude the cross-examination of the respondent, here, they, after about 6 hearing dates, they file an application seeking re-examination of PW1. My lords, now when I've concluded the cross-examination, if there is any ambiguity, they were to re-examine the witness on the very same day. My lords, now what happens is after six hearing dates, if they come after I lead my evidence, after my exhibits are marked, when the matter is posted for my cross-examination, they come up with this application and say that they want to re-examine the witness. Then they file a memo stating what questions they would ask. My lords, this is to fill up the lacunae that's in the cross-examination. What
Let's
she has
look at the
admitted.
order at page
Please.
24.
Twenty-three, my lords. In fact, it's a 2-page order, not a speaking order also.
Oh, where is the cross-examination?
Page 49, please. Page 49. Ordinance para number 2, which continues in the next page, wherein it's stated the said photograph is marked as exhibit R4. I used to take alcohol extremely rarely. I do not smoke. Now I take alcohol also. I have not produced any medical. That is what they claim in their application. My lords, at para number 3, it is true to suggest that I was in live-in relationship with the respondent. Now, my lords, if they were really aggrieved by this, if there was any ambiguity to this, they should have re-examined her after I concluded the cross-examination. They do not. They train the witness, then they. My lords, please.
The said photograph is marked as exhibit R4. I used to take alcohol extremely rarely. I do not smoke. Now I take alcohol also. I have not produced any medical document to show that I got injury from the assault by the respondent. I had filed complaint before the police against her. I have produced copies of the said complaint before the court. Now
Then-
again, please come back to that order.
24,
Page 24,
22 to 24.
22 to 24. Petitioner filed a memo that is required to ask the petitioner whether she has the habit of taking alcohol and she has any live-in relationship with the respondent since 2010. Respondent has filed the objections as under. Application is not maintainable, there's no need for re-examinations, and there's no ambiguity in the evidence. Petitioner is permitted to cover up the admissions given in the
Now,
cross.
even if this is allowed,
Please.
she has already said like she's in the habit of taking alcohol.
It's not just that, the next one also, Your Lordship, para 3, if Your Lordship goes back to page 49. This is the second portion she's trying to correct. Page 49, para 3. I've gone through the contents of the examination in chief before filing it before the court. It is true to suggest that 2010, was in a live-in relationship with the respondent.
There is a reason why I'm saying she was divorced to give up the second marriage for her.
So
So
she has
the-
already accepted it.
Please.
Then how it will be taken away, that admission?
Going to correct it by trying to give an explanation to the whole thing. Your Lordship may kindly see their memo. What happened was she's a divorcee.
Let's see
For
the
her,
memo.
This is for
Where
her,
is the
this-
memo file?
Please, please.
Page number.
The last, Your Lordship. At page 62, Your Lordship, Annexure G.
Lordship has it, page 62. During the cross-examination of PW1, photograph was confronted and the said photo was marked as Exhibit R4. At that point of time, the petitioner was answered that she has taken a sip upon his insistence, but the same has been recorded as, I used to take alcohol extremely rarely, and also recorded as, now I take alcohol also, at page 9 of the deposition. Re-examination question, what they want to ask, do you have any habit of taking alcohol? Now, number 2, during the course of cross-examination, petitioner had answered that I had liking, the English is terrible. Now, so what she's trying to say is, it is not as if they are trying to say, Nani, what answer we gave was recorded differently by the judge. And so now what answer we gave should come. Your Lordship, that is why last time I said, normally after the evidence, the court gives us the copy. And in fact, they sat for very long, in-depth, read it and then signed it. Now for them to say, this is what I said, but it has been recorded wrongly. After that, 6 hearings have taken place, Your Lordship. Had they also by oversight missed it, they would have mentioned it to the court the next hearing date. 6 hearing dates later, now they come and say, I want to correct this mistake. And the reason she also wants to cover up the live-in relationship is, Your Lordship, for her is the second marriage, not for him. So at that point of time, her marriage was still subsisting with the first one when she was actually living. And that is an admission that's come. So now to undo that would be correct. And Your Lordship, I understand this will already be on record, but then the reasons for re-examination, Supreme Court's very clear, re-examination, what are the reasons? It can't be on that same issue only if there is some ambiguity or whatever. Here, what she's trying to say, what answer I gave was not recorded. It was recorded something else. She's saying, she says specifically says that it was recorded as so-and-so. Petitioner answered so-and-so, but then it was recorded as so-and-so. So that may not be permitted, Your Lordship.
May I ask? For their contention, either in the not of the WS, they have filed, not or in the chief examination stating that not she drinks the alcohol, as well as not she had not live-in relationship with the not of the petitioner hearing. Not it is not their contention, not of the before the trial court in their not of the written statement. First, not the secondly, not the what kindly it cannot be not that sentence should not be read in isolation. Kindly see not. I do not smoke. My lords, may I take note page number 49? What is the evidence? I do not smoke. Now I take alcohol also. My lords, if my lords, I would have take the alcohol, I will drink alcohol also. I will drink the alcohol, she would say. My lords, I take alcohol also. My lords, I do not, my lord, that is missed. My lord, that should not be, my lord, read in isolation. Not that I do not smoke. My lords, once again, I will repeat that sentence. I do not smoke. Now I take alcohol also. Lords, do not, Lord, that is the Lord's error missing. That ambiguity, Lord, this should be clarified in the Lord the re-examination. Even Lord, after the cross-examination, immediately next date of hearing, Lord of the my counsel, Lord, who is appearing before the trial court, he brought into the knowledge of the court. The court is after cross-examination, you re-examine the Lord the petitioner hearing. Lord, he took Lord 2 years to cross-examine. After cross-examination, Lord, the last time, Lord, junior counsel was appeared in the trial court, Lord, he did not know about the Lord, the things and all. Lord, after Lord, it is adjourned for re-examination. Meantime, Lord, went and filed an application. That application also, Lord, they did not file along with Lord this writ petition. In that, Lord, she clearly stated that. Lord, she stated that, Lord, she will not, Lord, she do not smoke, as well as she do not drink also. Lord, she stated. Lord, that as error, Lord, they kept in this matter. Even Lord, the learned trial judge also not. Even apart from that, not that not the she Lord, it is mentioned that not since 2010, Lord, she is in live-in relationship. Lord, it is there not their case that Lord she had Lord live-in relationship with him. Fact is that Lord, she likes Lord since 2010. Lord, that it interpreted like this, Lord, in this. That is the Lord, the only Lord, the I have sought for Lord the re-examination. Lord, they are having opportunity to cross-examination and then Lord, there is no error in the Lord the order of the trial court. And moreover, Lord, the exhibit before is concerned.
Once a cross-examination is done.
Yes,
everything is recorded by the court.
Yes,
that would be given to the respective advocate, client to look at it.
In family court, not burden of cases is not the more, not there. Even not, they won't not allow us to read there, because not the crowd is so much, not, we cannot read also. On the next date of hearing, not, my counsel, not the land, who is appearing in the trial.
That have you mentioned in your
No,
application?
no, application, not the.
If you have a copy of it, please pass on.
His application is filed. Page 56.
Page 50?
Yes, IA number 6 has been filed, page 56. Affidavit follows the next page. You can
For
follow.
the reasons,
Third para.
please recall the order. Para 3, respondent has completed the cross-examination of PW1 on 211. In fact, respondent took more than 2 years to complete cross-examination, but certain answers wrongly typed, and many times my advocate submitted for re-examination. Then this honorable court suggested to re-examination after completion of entire my cross-examination. On the last day cross-examination, my senior counsel was held up in some other case and his junior counsel was present, which is false because the initials are recorded there. The senior was themselves there, so that is also wrong.
Conclusion, if the senior counsel was next date, they should have filed.
And now they say that they completed it on 211. Lordship may kindly see the number of hearing dates after that, after 211.
3 months to file.
No, is it correct that immediately on the next day it was brought to the notice of the court that there is a typographical
No,
mistake
absolutely
in
not.
that?
Absolutely not. In fact, Lordship could even verify with the learned judge, and we can also file it on affidavit to the to that effect. That was not the case at all. That was the case we would have.
For 49 page number cross-examination, on reading, there's 2 sentences, previous sentences and next sentence. That itself, they clarify that, there is some missing. Nobody will tell that I will take alcohol also. First sentence is I do not smoke.
It is whose case is that she takes alcohol?
It is my case, not.
No.
No, it's in our cross-examination.
Whose case is that?
Pleadings.
In the pleadings, is it the case of the husband that?
No, my lord, that is why I am telling you, my lord, in written statement, they didn't say that, my lord, she will say to smoke and drink. And also, my lord, she had live-in relationship in the year 2010 itself. It is not their case. But only, my lord, try to improve, my lord, while in the evidence. In the evidence also, my lord, she correctly stated, I will not smoke, I do not smoke and I do not drink. My lord, that, my lord, I do not drink also.
Let us take for a minute, your lordship, that he's saying that that is a typo, that not should have come. If that's the case,
Then
the previous line, your lordship,
from
one minute, from page 49, it says, used to take alcohol extremely rarely.
That is
So
the
then-
rarely she stated.
What she's trying to say is,
Now also.
with respect to smoking, she does not do. With respect to alcohol, yes, she takes.
If she takes notes, I will take, she would have said it. Kindly, not the, that 2 sentences, not clarify the things, not. That,
But it is,
senior
it is
counsel
like
is not.
this. Now, some admission which is made, you can't.
I do not, sir.
All
That
those,
may I
cover the
request-
latches,
yes,
you can't be given
yes,
that
yes,
opportunity.
May I request not. In earlier sentence, I did not ask for re-examination. Only the sentence, I do not smoke, now I take alcohol also. Not that sentences along with the, since from 2010, I had live in relationship with the respond. That is the 2 sentences. In their entire written statement.
So what is according to you, what is wrong with this sentence construction?
Now I do not smoke.
No,
and
para 3.
The para 3 sir. She liking since 2010. It is not the mistakenly mentioned live in relationship. It is not their case that I had live in relationship with him since 2010. Let them show one sentence from their the written statement. Either I drinks or I had live in relationship with me. I am the out of the court.
So why that live is like struck down?
No, there I had, in
That is
there,
a correction.
there's
That
a
is like-
correction which the judge has made
That's
on the
that live-
typo. It's true to suggest that since 2010, I had a live-in relation. We were in live-in, so that typo has come. We in
No,
relationship.
how can there be I had we in?
I had this live-in, your lordship, the question asked was, were you in a live-in relationship? It is true to suggest.
No.
That is the
what
answer.
No, it appears to be an initial of the judge.
Please.
That's an initial.
This is written as LIVE.
But that is struck off an initial is put
That
there.
was in relationship, that was-
It is only, I had in a, I am in relationship with respondent.
Correct. So he cannot now have an objection, even that live or whatever is struck off, relationship, if she says that she was only friendly, that relationship will also be the same. Ultimately, that anyway correction and thing is, there's a signature. What more could they seek correction, your lordship? She has been in a
One,
relationship.
let
with
them show, my lord, from the written statement, one word, my lord, stating that I had live in relationship since 2010.
No, where is
First
the-
one. Second one is, my lord, let them show from the written statement that, my lord, I had, my lord, I used to take the drink, or, my lord, I do drinking and all.
But unfortunately,
Thing is
who
there,
asked her to say that? And now that is
But
such a
moreover,
crucial
they are-
admission.
Moreover, they are having not a right of cross-examination. If that is so, my lord, let them cross-examination from their pleadings. There is no pleadings at all from their side. My lord,
Cross is
no,
over, re-examination, the judge specifically asked twice, they said, no, we don't have any re-examination. Then after that, and there is no such crowd and the correction, no. Second half is never crowded, first half is very crowded in family court. And your lordship would know better than all of us because your lordship is in charge of those courts. Second half is never crowded. We have,
Yes,
in
we
fact,
can.
the entire bench is enough place for even 10 juniors from one office to sit down and do correction. The senior was there, they're made, it's the submission that is made false in their affidavit. Counsel was there, the other side senior only was there, no junior that was there. 6 adjournments after that. And after this, they have filed their application in February suddenly.
No, even otherwise, if you look at it,
Please.
that she's a educated woman, that she's not understanding, she is understanding about the consequences of the question you're putting
Correct.
and what are the answers she should give.
Correct.
When it is nobody's case, why would she make such a suicidal statement saying that I'm in relationship, I drink, I smoke?
No, yeah, that she's very smartly said that,
R4
yes, I do,
R4
but
is a-
rarely.
R4 is a-
She only says that I occasionally drink. That is her statement, that she occasionally drink,
And what-
but she does not smoke. She's very clear. With respect to smoking, she's very clear that she does not.
Exhibit
with-
R4 is a
And-
drinking photo.
As
Your
he,
lordship,
as he
our
rightly
phone-
puts it, no, I used to take alcohol extremely rarely.
Correct.
That's one sentence. I do not smoke.
Yes.
No, I take alcohol. No, she
That is
says,
because of the exhibit, that R4 is a photograph of her drinking.
Lord,
So now he cannot undo it. I am showing a photograph and then asking. So she cannot even lie on that.
Lord,
So it is not as if it was something that was asked misleadingly and therefore a question that was wrongly put
so
or answered.
when that photograph is shown, exhibit R4, she
Correct.
says, I used to take alcohol extremely rarely. I do not smoke.
Yes.
Now I take alcohol also.
Lord, that sentence itself, my lord, clearly shows.
Your
No, no.
lordship, if correction has
What
to
is
be.
exhibit R4?
R4, my lord, I will explain. My lord, the exhibit R4, my lord, in that exhibit R4, my lord, her mother-in-law also is there, my lord, it is in the car. It is, not that photograph is not in the 2013 or 14. 13 or 14, not I think. That photograph is 13 or 14. My lord, sir, in that photograph also, my lord, sir, their mother-in-law insists, it is our family culture to have, my lord, sir, some occasional drinking and all. You join to our family. If you not drink, at least show that as if pose that as if drinking. See, my lord, they put that thin to the, my lord, the mouth. Lord, that photograph she clicked, Lord, this 2013 and 14. Now, Lord, she wanted to misuse that photograph. Lord, that is the thing. Lord, that is why, Lord, I try to, Lord, morning, Lord, submit that. I am ready to, Lord, objection also is there, Lord. I will file my objection. Lord, the fact is this, Lord, what my Lordship is now heard, Lord. Fact is that much only. Lord, I do not smoke and now I do not drink also, my Lord. That is, Lord, I take alcohol also. Lord, it can't be a such sentence at all. It can't be a such sentence. Lord, I read, my Lord, minimum, my Lord, 100 times that word.
This was done on 23/11/2021.
Yes, my Lord. Immediately, my Lord, next date of hearing, Lord, which has been brought into the knowledge of the, my Lord, the trial court, saying that, my Lord, which has been crept out. Lord, the learned.
There should be an application for that. It is not
Correct,
about
Lord.
bringing
What
notice.
happens, Lord?
Now, what will happen is they deny it.
Lord, what will happen, Lord, in while doing the cross examination? After completion of the cross examination, you are having, Lord, the liberty to re-examine. You do it. You said, Lord, the learned judge also said, Lord, they, according to my colleague, my lords, learned friends, my lords, where they, other side was also present. But he did not object at that time. And my lords, after my lord cross-examination, they took my lord 2 years time. My lord, subsequently, my lord, they have made this application. Even my lords, even for making my lord this word, they are having right to cross-examination. If that is so, my lord, if I drink, my lord, I should say, my lord, I will drink. If I didn't drink, why should I, my lord, they mention all this? This is the my lord.
It is not as simple as that. If you appear on that side, if you appear on that side, would you let them to take away such an admission?
Yes, my lord, it is, I am not taking away that admission. Even my lord, that sentence kindly, my lord, 10 to my lord, the 12 times, my lord, I read that sentence. Not that doesn't give any, my lord, my lord, the sense. I reading
So
this.
further cross-examination
Even
or
other
further examination is not for the
That,
purpose
my lords,
of
I did not deny, my
taking
lord.
away some of the admissions you made.
Yes, I
How
do
can it
agree.
be permitted?
But my lord, this, my lord, it is their not their contention that, my lords, I drinks, my lord,
They could elicit from the cross-examination.
At least, my lord, they should be pleadings one thing. Even, my lord, in cross-examination also, my lord, that is the ambiguity, my lord, so what I am requesting for re-examination. Because, my lord, in their written statement, my lord, nothing is there, my lord, I will drink alcohol or not. So
No,
I had,
now,
my lord, reveal.
till I come across this exhibit R4. Now,
under
she
what-
herself will not come and say that I drink. Now, exhibit R4 is shown to her.
Yes.
On that, she said, I don't, maybe
There-
whatever the
no,
sentence,
my lord.
I don't drink regularly, occasionally I drink.
Rarely, my lord, she said.
Whatever it is,
Yes,
occasionally, rarely. that-
Next sentence, my lord, if that is there, my lord, next sentence, my lord, she should not tell that, my lord, kindly, she, my lord, I do not smoke. Now I take alcohol also. My lords, I do not take alcohol also. Not the question they put is, my lords, do you smoke? Yes, I do not smoke. Do you drink? No, I do not drink. Do not drink also, my lord, that is mentioned. Not if, not the question was, not if you drinks, not you should say I drink. Also, my lords, it clearly shows that, my lords, I do not drink also.
If we have to go on grammatical errors, there are so many, Your Lordship. The sentences are so poorly put. We can't now ask for complete corrections on all of that. Now he is now trying English classes. If his application itself, I'm not able to understand half of it. Now do I ask for correction of his application and his affidavit? Sentence formation in his affidavit itself, even when I read, I can't make out what he's trying to say. Your Lordship, and then what explanation, Your Lordship? Some mother said keep it, so she kept. Now they'll have to,
That in
there is no mother in the
photographs
photo,
also,
she
my
is
lord.
drinking.
Mother-in-law,
here in that.
my lords, mother-in-law.
There is no such.
My lords.
If Your Lordship wants tomorrow, I will bring that photo
Yes,
also
my
and
lord.
show you.
Yes, my lord. Let
I
them
have no.
bring and show, my lord. No problem. Even mother-in-law law is also there, my lords, in rare seat. My lord, she is also, my lord, sitting, my lord, adjacent to her.
I type pass on you.
No, unfortunately, after these many years, without an application at an earlier, at appropriate point of time, saying that this is a typographical mistake, but not what you have stated. After 2 years of this this cross-examination, you can't be permitted to
correct,
take
Lords,
away that
correct.
important admission. Take the judgment. What is that? Yes, which para?
Might I take Your Lordship to para 16 at page 6, Your Lordship? Para 16, we may add a word of caution. Power under 151 or 18 Rule 17 is the code not intended to be used routinely merely for the asking. If so used, it will defeat the very purpose of the various amendments to the code to explicit trials. But where the application is found to be bona fide and where additional evidence or oral or documentary will assist the court to clarify the evidence on the issues and will assist in rendering justice, then the court is satisfied on non-production. Earlier, it was valid for sufficient reasons. The last 4 lines is with respect to us, Your Lordship. Court should firstly award appropriate costs, so and so on. Secondly, the court should take up and complete the case within a fixed time schedule so that the delay is avoided. Thirdly, if the application is found to be mischievous or frivolous or to cover up negligence or lacuna, it should be rejected with heavy costs. If the application is allowed and the evidence is permitted and ultimately court finds that the evidence was not genuine or relevant and did not warrant the reopening of the case, recalling the witness, it can be a ground for awarding exemplary cause, and apart from that, ordering persecution if it involves fabrication of evidence. The party had an opportunity to produce such evidence earlier but did not do so, or if the evidence already led earlier is clear and unambiguous, or if it comes to the conclusion the object of the application is merely to protract the proceedings, court should reject the application. The evidence sought to be produced is, that's irrelevant. Your Lordship, is mainly applications allowed, evidence permitted. It should not be to cover up negligence or lacuna. This is only mainly that. The next one, the Delhi High Court judgment, Your Lordship, page 13, para 16 again, Your Lordship. Needless to state that any interpretation in respect of the answers given by the witness can be addressed by the counsel at the time of making submissions. Re-examination cannot be used to give a chance to the witness to undo the statement of the witness made in the cross-examination and fill in the lacuna in the evidence. The next one, Your Lordship, is at para 14, 15, and 16 at page 19 and 20. Para 14. Besides this, in the judgment referred to above, Honorable Apex Court, while examining the scope of inherent powers under 18 Rule 17, so, Your Lordship, can be exercised by the court in its own motion on an application filed by the parties to the suit requesting the court to exercise such power. The said power being discretionary should be used sparingly in order to enable the court while trying a suit to clarify any doubts which it may have with regard to the evidence led by the parties by recalling any witness so that the court can put the questions to elicit anything. But most importantly, in the judgment referred to above, has held that the power is not intended to be used to fill up omissions in the evidence which has already been examined. Honorable Court has held and so deleted with effect from so. Deletion does not mean that no evidence can be received at all so. Lordship, the next portion is just at para 16, the topmost line in page 20. Omission in the evidence already led by the witness cannot be used for the purpose of filling up a lacuna in the evidence.
It is not the divorce petition filed by the wife. It is not the case that I am dragging the matter and all. She took admittedly friend also said not 2 years she took for cross examination. It can't be the applicable to my case. My case is only nutshell that they do not drink also. I do not smoke. Now I do not drink also. That is the word she stated. The error has come in the cross examination. And the 2010 she had live in relationship, it has come. At least liking that is it is not their case that since I have 2010 I had the live in relationship. It is not their case at all. And moreover, and that also I do not drink, it has to become that the ambiguity should be clarified is my respectful submission. And they are having right of cross examination. She will not drink the alcohol. The one who will not drink alcohol, you mentioned that she drinks alcohol. It get hurted. It is minor mistake, because of the hurt caused to the respondent hearing. Apart from that, that photographs also I tell. He is misusing that photograph, the everywhere. That is they took in the year 2013 and 14. Mother-in-law also the adjacent to sitting in the rear seat. In such being the case, I requested my lords to the order of the trial court is correct, does not seek by interference.
Agreed with the orders passed in. I number 6 and MC number 2673 of 19, dated 2/4/2024, whereby the petition filed by the respondent to re-examine PW1. So it is application filed by the petitioner.
The respondent.
Respondent to re-examine PW1. No, not not here. Who has filed the MC?
By the petition.
Filed with the petitioner to re-examine PW1 came to be allowed, aggrieved thereby, the respondent, respondent in the MC, that is the petitioner here in the husband, is before this court. The wife had filed MC 2673 of 19, seeking divorce. In that, the wife, the parties are referred to as wife and husband for the sake of, for the convenience. The wife was cross-examined on 23/11/2021. In that cross-examination at para 2, it is stated that the photograph, within inverted commas, the photograph now confronted to me is my photograph, full stop. The said photograph is marked as Exhibit R4, full stop. I used to take alcohol extremely rarely, full stop. I do not smoke, full stop. Now I take alcohol also, inverted commas close. Then again at para number 3, it is stated that it is true, inverted comma, it is true to suggest that since 2010, I had relationship with respondent. Full stop. Presently, I am living with my parents and also with my son. Close. It is a case of the wife that during her cross-examination, a photograph was confronted and the said photo was marked as Exhibit R4. At that point of time, the petitioner answered that she has taken a sip upon his insistence, but the same has been recorded as, I used to take alcohol extremely rarely, and also recorded as, now I take alcohol also. It is stated that in the re-examination, now they want to put a question. Do you have any habit of taking alcohol? It is also stated that during the cross-examination, the wife answered that I had liking, as it is right, inverted commas, I had liking the respondent as a friend since 2010, but is recorded as since 2010, I had live-in relationship with the respondent. Hence, they want to ask her by examining the PW1, they want to question, do you have any live-in relationship with respondent since 2010? The said application filed by the wife came to be allowed, wherein the court has observed that it appears that the questions to be put at the time of re-examination does not take away the defense of the respondent. Moreover, the respondent is having every right to cross-examine the petitioner after her re-examination. If the application is allowed, no hardship will be caused to the respondent. Accordingly, allowed the petition. Next paragraph. Let a senior counsel appearing for the petitioner, husband, submits that. Now, in the cross-examination, she had admitted certain facts. Now, by way of this cross-examination, by way of this further examination, whatever the admissions that are made by the wife, they want to take away the said admission which is not permissible. It is submitted that further examination cannot be for the purpose of filling up the lacuna on the part of the wife. It is submitted that once the cross-examination is recorded, the same would be given to both the counsel. It would be given to the counsel, would be given to the party and the counsel. And after going through that, then the party would sign the same. In this case, it has happened. And after going through the answers and the cross-examination, they have signed the same. And thereafter, the husband was cross-examined. And after the cross-examination of the husband is completed.
He was still not cross-examined. It was posted for his cross-examination.
when the matter is posted for his cross-examination, now the present application came to be filed. It is submitted that the court below ought not to have allowed such an application, which definitely causes prejudice to the husband. And the senior counsel has relied on the judgments of the apex court in case of KK Veluswamy versus N. Palaniswamy, reported in 2000 AR SCW 2296, and another judgment of the Delhi High Court arising out of CS within brackets OS 3379 of 2015, dated 1st June 2022. And also, and the judgment of the Himachal Pradesh High Court, reported in 2017 SCC Online HP 1414, in case of Deshraj and another versus Kesharam and others, wherein the sum and substance of the said judgments is that in all the said cases, the judgment of the Honorable Apex Court in several cases has been relied on, wherein it is the ratio laid down is that the re-examination cannot be used to give a chance to the witness to undo the statement of the witness made in cross-examination and fill in the lacuna in evidence. It is submitted that in the light of the above judgments, the writ petition is liable to be allowed. Next part. When counsel appearing for the respondent wife had taken this court, has drawn the attention of this court to the memo and also to the cross-examination. He submits that when it is nobody's case that she had a live-in relationship or she drinks, on the face of it, it shows that it is purely a typographical mistake, which has to be as such. They have come up with this application for re-examination. He submits that once the petitioner is re-examined, the wife is re-examined, the husband would again get an opportunity to cross-examine her. As such, no prejudice would be caused to him. If this remains to be on record, it causes a lot of hardship to the wife. He submits that immediately after the next day, after the cross-examination, this is brought to the notice of the court that such a typographical mistake had taken place, and court had observed that. Court has informed that this always after the cross-examination of the defendant, they'll get an opportunity. After the examination of the defendant and the respondent, they would get an opportunity. At that time, these things could be raised. As such, they were waiting for the same, and the defendant took almost 2 years for completing the same. Next paragraph. In response to that, the senior counsel appearing for the petitioner submits that as submitted by the petitioner, no such mention is made before the court, nor the court had permitted them, had stated as submitted by the learned counsel for the respondent. It is submitted that the matter underwent on several occasions. There was an opportunity for the respondent wife to come up to bring to the notice of the court that some typographical mistake has crept in the cross-examination or in the gist of the cross-examination. But no such effort has been made, and now it is not open for them to agitate the same. Next. Having heard the counsel, having heard the senior counsel and the counsel for the respondent, there is the entire material on record. In this case, the wife's cross-examination is complete on
2/11/2023.
on 23/11/2021.
2/11/2023 was completed on 2/11/2023.
It is completed on 2/11/2020. No, it is 23, it is
23.
completed in 2023. On, now the,
Synopsis may be perused, my lords.
now the part of the cross-examination which the petitioner, which the respondent wife is aggrieved and why she wants a re-examination is dated 23/11/2021. In that, as extracted in the above paragraphs, there are certain, in the cross-examination, the petitioner could elicit certain things from the respondent with regard to her consuming alcohol and with regard to the relationship from 2010. According to the respondent, that is a typographical mistake, if at all, and she has not made such a statement before the court. If at all it is a typographical mistake, for that, they cannot wait for years together. It is not bringing it to the notice of the court orally, as they have to file an appropriate application and bring it to the notice of the court as that admissions as those admissions are fatal to the case of the wife. But unfortunately, except submitting that, only an oral admission, orally they have submitted to the court. There is no such application filed earlier, which is, and the same is not placed before nor it is placed before this court. The fact remains is they kept quiet till this application is filed. As rightly now, by virtue of this IA, they want to give another, again, re-examine her, give suggestions, and basing on that, in a way, they're trying to take away the admission that is already made by them, that has already been admitted by the respondent in the cross-examination. In the series of judgments of the Honorable Apex Court, the purpose and purport of re-examination of the witnesses has been discussed, and that can never be allowed to cover up the latches on the part of the, to cover up the latches on the part of the party. Under these circumstances, this court is of the view that the court below, the observation of the court below, that no prejudice is caused to the husband if such an application is filed, is not correct, and the same is liable to be set aside. Accordingly, the writ petition is allowed, then the IA dated so and so is set aside. Yes, next.
Great. 19.
There.
19. Chandana Tariga, K for petitioner.
Where is he? Your matter. What do you say on that?
Kindly see page number 166, what my learned friend is saying is not correct.
Page number?
166 of the records.
166 of the
Records. What is placed before?
Have you seen?
Yes, my lord, I have seen it.
Yes.
And that certified copy is also of the same document. That also bears the number 166.
Kindly see that. What?
Switch on this fan also. Fan. Small one.
That vis-a-vis annexure E may kindly be see.
It's
Annexure E.
0.06.
Yes.
Here it is mentioned. In your case, it is 0.16.
My lord, 0.16, kindly see this third item. yellow marked, yellow flag.
Oh, I'm seeing here, it is 0.06 only.
My lord,
There are green, orange and pink. Green is 0.14.
Yes.
Orange is 0.10.
Yes.
Blue is 0.06.
my lord,
Whereas in your case, blue is 0.16. What document you have filed?
that is examined by the court and the court copy itself is filed. Xerox.
How?
Yes.
Court copy is before the
Not
court, my
court.
lord. How can it be, my lord?
No, I will make a copy is taken and
No,
that.
let us just, 1 minute, 1 minute.
Yes,
Let
yes.
me just look at it.
Kindly see.
Where did you file? At page number?
Annexure E, page 34.
Page number 34.
Yes,
But a copy application is filed.
yes.
True, my lord. I have filed the copy application and taken the certified copy, which my lord, I produced it.
No,
in the
no.
morning.
This is also obtained from the court. What he filed.
Lord, in that case, I am not aware as to how there can be a discrepancy
That's
only
what-
insofar
we
as
have to
that
find out from the court
0.016
what
is
is happening.
concerned.
How
Zero-
can it be, how can the court give give a copy contrary to the original record?
Lord, that is what, my lord, it's extremely surprising as to how this could happen. When the surveyor report says it is 0.06, only when
That's very interesting.
the original one, 0.06 is there before
No,
the
no,
court.
no.
Only in the certified copy, how can it be 0.16?
Notes good.
There cannot be two sketches, except
There
that point.
my lord, there are two sketches. Kindly permit me to verify the records again. There are, because I was rattled by the statement made by the other side. I thought I should not proceed with this case. Immediately, I contacted the local council. He said there are more than one
No,
sketch.
in the record, there is only one.
No,
In the
There is-
record, it is only one.
no, there is at page 389, field sketch by the Deputy Tashildar, Land Tribunal,
1 minute.
page 389. Page 389. That is not a color sketch.
No, there is nothing in this 389.
Page 380.
389 is some tehsildar, something is
Yes, yes. Field sketch by the Deputy Tashildar Udupi,
there.
which is attached to the order of the Land Tribunal. Land Tribunal, first, my lord, the land.
Now, you have filed some document
Yes,
before this court,
yes.
which is marked as an exhibit. Let us see which exhibit is it from the backside
My
of
lord,
this.
my lord, yes, kindly.
It is. Where is that? That is filed by you as exhibit. Which is that exhibit? And we have to look at it from the record.
May I also help the court, my lord?
Court
Kindly
officer,
put
you
up
take this. Now, give that file, this one. Now, you have filed this document, referring it to as copy. Exhibit C6. Just look at it. What is exhibit C6? There is an index to that. Oh, take which page number you said just now? Three?
That is 166.
Take that 166. Then the exhibit number must have been written on that. Do you find the exhibit number? Huh?
My lord, may I? Sorry, may I do one thing? there are about 600 pages.
Come with an application here.
If the court permits, beyond 5 o'clock, I will sit here. My instruction by the local council
Exhibit
is
6.
Sure. Yes.
It's
that
a
is
color,
exhibit
colored,
6.
my lord. It's-
Same.
It's colored. 1 second.
Give it to him. What copy you have filed before this court and what is that should be one and the same. Do you have the paper? Look at page 34 of his paper.
Yes, madam, 34.
Backside of.
The one side is given to me. The back side is not given.
It is exhibit 6, C6.
The back side.
Nika? Many of the matters did this court ask for a bond. The child to come to the court.
389.
The boy is there, the court. Children are being brought to the court for no reason. Ask.
Lord, would your lordship give me a day's time, because I will sit here. The counterpart says that there are 2 sketches. I will just go through it and make submission. Otherwise, I am rattled by this, because I don't want to bring before the court a document which is not there. If that is so, I have informed the council that we have to withdraw the petition. To that extent, I have said. Therefore, if the court pleases, beyond 5, I shall sit and go through.
My only worry is this, my lord. This is the 25th hearing the matter is coming up.
But
That's why.
maximum 26 it will conclude.
So what has happened is decrease of
Possibly
the.
at any cost, it will come as part heard on Tuesday. And we'll hear it, whatever is,
Please,
even if you are not there also, your matter will be heard.
my,
Post this matter on Tuesday, finally, no further adjournments will be granted.
I may be
At the request of counsel for the petitioner, petition is permitted to look at the lower court record,
Please.
to verify the lower court record. Yes.
maybe recorded as it is part heard.
Huh?
It may be
Part heard, post as part heard.
Please.
Cell number 22,
Yes, 22.
Ramurthy, Akash B. Shetty for
Correspondence, my lords, praise time, my lords, day after tomorrow, my
No.
lords.
Where is that matter? 15?
22.
20, serial number 22. Short date may be given, my
22.
lords. 22.
In spite of moving a memo in the morning and again in the afternoon, sought for time. This court has passed over the matter again at 2:30, again a short passover is requested. Now the matter is called at 3 o'clock. Again, they're seeking for a short adjournment, which is not possible. Pose this matter on July 8th. August 8th.
Interim order may kindly be extended.
Interim order earlier granted is extended till then. Yes, next.
Cell number 25, Shahrukhin for petitioner.
This matter was heard earlier.
Huh.
This matter was heard earlier. Your lordship directed us to file
Oh,
documents
that
in
is the
support
matter.
of our claims.
Today is produced, my lord. These documents were never produced earlier. And also,
So on the last occasion, why it was adjourned is, why don't you people think about a settlement?
that's what
Right.
I suggest to him, my client is, I have convinced him for a settlement. He has convinced, my lord. I also given the offer to him. I wish
So
him
what
to settle.
thing is,
Your
if it's on
lordship,
the merits of the,
your lordship, after hearing,
directed us, both of us, to file documents in support of our claim.
No,
In
no, no.
addition,
Why-
my lord,
no,
if
no, no.
possible,
No, 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 no. Why a court asked is
Yes.
because now that D1, whoever it is, from the vendor of both of you,
Yes,
your
yes.
vendor
Yes.
is having how much extent, how much you purchased, how much he purchased.
that is
That
why,
the court wants to know.
that is why, my lord, he is not producing any documents. I am producing,
there.
my lord, copy of the sale deed, my lord.
Uh,
No. He, now he wants to claim he is a prior purchaser, my lord. But the Honorable Supreme Court refunding the matter, we don't,
no,
there is
all
no option
that,
the High Court
Mr.
decide how it
Kamsi.
is between the petitioner and the respondent.
All that we have seen
Ah.
on the last occasion, you're able
Sort
to.
of settlement, my lord, yes.
No, no,
No,
it's not. Even for a settlement also,
Yes.
if to arrive at a settlement, what is a property purchased by your client? What is a property purchased by his client? Any
Sir,
compromise would be
I'll
basing
make a
on that.
schedule and give it, my lord. I'll be called on Monday. I'll make a schedule and give it. Draw a sketch and give it, my lord. I'll call my
Not
client.
only that, he has to produce
Yes.
copy of the sale
This
deed.
document for the first time it is saying the light, my lord, has not been produced in the suit. It has not been produced in the final decree proceedings.
You know, we are not going into all those issues. It's all about the
I'll go with your lordship's
property
suggestion, but-
now. For example, if this court says that, whatever the arrangement, no, for example, 1 acre fell to the share of your vendor in the partition. In that, you purchase something, he purchased something.
Yes.
Via media, something would be decided so for that, he has produced the
Copy
sale
of the
deed
sale deed.
by which he has purchased the property. So you have to also place the sale deed before the court to know that there the compromise will start.
I'll look into it, my lord. I'll
Why
talk to
it
my,
is not there?
I'll try to sort it.
Lord, thing is this, my lord. My party, my lord, immediately after purchase in the year 87, my lord, put in possession, half portion.
But
And
unfortunately,
Kata was changed in my name.
what the big mistake that is done in this case is when once in this in RA, when an order is passed, in that order, as if instead of filing a review, when something is written like for being mentioned without mentioning about anything, because it's an executable order, you have to have it clarity that you didn't bother. You means your client didn't ask for any clarification in that.
No, my lord, RP was filed, my lord. In that RP, it was held that.
Unfortunately, in that RP, what has happened, like if RP is, there should be an independent order detailing everything. It has happened for more or less like for being spoken to.
No, my lord, in RP, what the court has done is that, my lord, I am the earlier purchaser, 1987, my sale deed. And he purchased during pendency of the suit, hit by list
But there
pendants.
is no such mention in the RP.
That is
It is
not.
just like that wherever defendant number 2, in that place,
That
replaced.
was done by Supreme Court, my lord.
No,
Wherever.
The review it was done.
No, in review, my lord, court has held that, my lord.
Supreme Court, what it did was, now who is entitled, we don't know. We will not decide it in these proceedings. It has to be decided by some other proceedings.
No. Supreme Court what said is that, my lord, the para 8 of the RSA order, wherever D9 is there, you replace it by representative of the D1. That is what Supreme Court said. Representative of D1, who is representative of D1? I am the first purchaser. I am the representative of.
No, that some court has to say.
That's why, my lord.
Executing court cannot say that. No, the difficulty is, now this court also can't do anything.
No, now, my lord, because of that reason, now she has filed FDP.
They have to come up with
Yes.
please get your,
Please,
no, forget about his sale deed.
Yes, yes, ma'am.
Whatever he has purchased, whatever piece of
We
paper.
don't know, my lord, whether
Let him-
she has, my lord, purchased the entire property or whether a portion of the property.
I'll
Or
put it to
same
my client,
property.
what
No,
best I
without there
can
being
do,
a document, court below has granted, held that they are the subsequent purchases.
Lord,
The court below,
no, my
trial
lord,
court.
before the court below, my lord, her case was not considered. On the other hand, D2, that is my party's case was considered, and a share was allotted to my party, my lord, which was allotted to D1, who sold the property in my favor. That is the operative
So at
process.
any point of time, the document of the defendant, this purchaser was never marked.
Never forthcoming. That's the problem.
It's not so
Even,
much.
even before this
As
court.
your lordship, this identification issue also, I'll put to my client, I'll make this thing also, I will make it very clear on Monday where we stand, both of us.
Let him produce, my lord, the document, registered document that he is having, and Kata certificates and other
That,
things.
that would not give them a better right, my lord.
Ah.
Not
Just
right.
because they have the khata in their name.
No, no, no. When you're saying that you purchase, there should be something.
Yeah, that's right. my lord.
That is called a registered sale deed, or what is it called according to your client? That should come here.
I look into it. I'll put it to my client.
Suppose this matter on Monday, by the
Monday.
time the counsel for the respondent.
Let it be
take
taken
that.
on record.
The counsel for the respondent, yeah? The counsel for the respondent, take it. Counsel for the, This, no, that is not a part of the record, and let it be taken only for the purpose, so it's like, this file. No, that won't. What did you write? What's this? No, how can it be? We will take it for the reference, no additional documents now.
Yes,
This-
my lord.
Just a memo, write it as a memo, we'll
Yes,
take it.
my lord, I will
Just for the
replace it
reference,
by a memo.
because that can't be. A
But,
memo is filed, the land counsel, the petition has filed a memo to stating that he has purchased the property by way of a registered sale deed. Land
Lord.
counsel for the respondent also shall place before the court.
My lord,
What is the
I
extent?
will file a separate memo with the type, mentioning the boundaries purchased by me. Tomorrow I will file it.
Yes.
Right, tomorrow.
No, not required. The counsel for the respondent shall get instructions with regard, shall place before this court the document by which he has purchased the property. And it is only for the purpose of, both these documents are only for the purpose of the settlement between the parties.
Yes.